Delivery of order at 2. Yes.
And I filed a regular bail petition, my lord. The petitioner was arrested, my lord, on 3/8, my lord. Again, under my lord, some cattle preservation act, my lord. In the charge, result list.
What is your prayer?
My lord, can it be possible to taken it today?
No. When have you filed?
Yesterday, my lord.
Monday.
District of bail application. PA, lord.
When have you filed?
Monday, lord.
When have you filed?
File lordship 29/5, 1st of February. No, it is listed earlier. It's listed last on 29/5, and that the matter was deferred. So it was not sitting. 29/5 last listed.
Kityapari. 12.
Apply.
May I plead, Your Lordship? I'd like to mention a criminal revision petition 513 with 2023, Your Lordship. Your Lordship, in this case, hearing was conducted and order was reserved, Your Lordship. And it was the last date, the last posting was 21/5/2025, Your Lordship. And I beg to that it will be listed on Thursday, Your Lordship. Hearing was conducted, Your Lordship. The order was reserved for.
Listed for what?
It's for orders, Your Lordship.
Who reserved it?
Your Lordship?
I have reserved it.
Yes, as per instruction by senior, my Lordship. The last occasion, Your Lordship. Case number 5, criminal revision petition 513/2023.
I'll check it.
Yes, yes, first.
Okay. Yes.
Item 28 for withdrawal.
Yes. Heard Mr. V. Why are you withdrawing?
Instructions of my client.
Heard Mr. V. H. Chaudhary, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
DP of
Daily list, Muslim way, item 2.
Where is your Lordship? Kindly, matter may be taken up for some time, my lord, on behalf of SC Whisper. UAP is there, my lord.
It is pending investigation. We'll call for the case. Heard Mr. What is your name? A.K. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case. Wait. When?
21.
List this matter on 21/8.
Item 3.
Lordship, my senior is on legs at another court. So kindly the matter may be passed to before the time.
Okay, we'll take it up after some time.
Item 4.
May I plead, Your Lordship?
You mentioned Kurisile. Yes.
My lord, pre-arrest bail application, my lord. Page 11 is the FIR. May I read, my lord?
Yes.
Long FIR, my lord. From the in between mentioned facts, my lord, I'd like to read from their facts, my lord. Airtel Payments Bank Limited, hereinafter referred to as complainant, is a banking company registered with RBI that conduct its operation through its business correspondence agents, which are located pan-India. These business correspondents operate through banking points and are on boarded as per the regulations and guidelines RBI after due verification and filing of necessary forms and providing necessary information. The role of these agents is to provide various banking services in remote locations where access to the technology is limited or non-existent. These agents have been equipped with various technologies and devices to perform these banking services. One such technology is the Aadhaar enabled payment system within bracket AEPS. Using the AEPS method, transactions can be done using the customer's fingerprint and Aadhaar details. According to the AEPS method, the customer can withdraw up to 10,000 rupees from his account using his fingerprint. However, recently some agents have started misusing this payment system and are committing fraud. Agents wrongly withdraw money from the customer's account without their knowledge. When customers get information about such fraud, they contact with their respective banks who inform National Payments Corporation of India about the disputed transaction. NPCI then sends information to the complainant company issuing chargeback. On receiving such chargeback, the complainant company has to pay their entire chargeback amount. Moreover, to ensure and monitor frauds by these agents, NPCI has issued guidelines that the bank has to follow. Hence, when a complaint of a fraud is received, the bank has to resolve the dispute as per NPCI guidelines and after conducting proper internal investigation. After preliminary investigation, the flowing agents retailers have been found to be cheating with deliberate and malicious intent. These agents were deliberately committing organized financial fraud, criminal breach of trust, wrongful loss to the bank. The details of the accused person, my lord. I am the, my lord. Last accused person is page 13, Saddam Hussein, my lord. And against me, I have committed fraud an amount of rupees 1,49,100. Yes, very record, my lord. This allegation against me, my lord, here. And in support of my case, my lord, why I want to submit, what I want to submit, my lord. Paragraph 7 of my petition, I would like to read out, my lord. Page 5.
Yes.
That it is most respectfully submitted that entire allegation made against the petitioner is highly doubtful and devoid of technical and procedural logic. As per the functioning of Aadhaar enabled payment system, it is a mandatory requirement that the customer must be physically present and authenticate his withdrawal by providing their own Aadhaar link fingerprint. The biometric device captures live data during the transaction and therefore unauthorized withdrawal without the knowledge of or consent of the customer is technically improbable. Inasmuch as, in such a system, it is not possible to bypass the fingerprint authentication or to fraudulently withdraw money unless the customer willingly participated or shared his her biometric details, which is also against law and policy. Furthermore, the FIR is completely silent on the most crucial aspect, their identity of the victims. It does not mention even a single name or account number of any person whose money has been allegedly misappropriated.
Because of the
Yes,
case, there is very.
yes, sir, it would be required.
How it is
Yes, after registering this case, 41 CRPC notice issued to me, not BNSS, 41 issued to me. And now I went to appear before the IO, my lord. Allegation is 1,49,000 and I am categorically denying the
You have
allegation.
appeared?
No, my lord. So I am seeking some protection, my lord. In the meantime, case very may be called for. I am ready to appear, my lord. So I can because my lord, just 1,49,000 allegation against me, and I am denying that same.
1,47,000 against him, but
Other
along with others, huge amount.
4 lakh something all total. But these are belongs to a separate area, different area. And Airtel Payment Bank nowadays, my lord, even separate BC, my lord, business correspondence agents in different area of the country. I am belongs to the particular area and I am not connected with the others. So I am seeking, my lord, I am ready to abide any condition, my lord. And in the meantime, protection will be given and
No, if customer's fingerprint is required, unless customer is,
But affair is that without happening by the affair by the Airtel Bank. So such things may happen. How it can be happen? It can be revealed from the case.
That's why.
Case diary,
Nowadays,
case diary would be required. Heard,
Protection
we are fixing short date.
Right.
Heard Mr.
take care.
A.K. Azad, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Considering the nature of accusation leveled in the FIR against the petitioner, perusal of the case diary would be necessary for consideration of the instant bail application. Instant anticipatory bail application. Hence call for the case diary. List this method. Give a short date.
Interim, but
19, no interim till.
Item 5,
Here is page 14 is the FIR. And the offense under section 13(1) of the Assam Cattle Preservation Act. Page 14, my. May I read,
Yes. How much?
my lord, in this case, I am not the FIR named accused, my. And nothing was recovered from me also, my lord.
Then
Yeah.
why are you apprehending?
My lord, apprehending because, my lord, police is searching me, my lord, and apprehending that, my lord, I approached the session judge rejected my bail petition.
Why?
My lord, co-accused to approach this honorable court, page 32, my lord.
Why session judge rejected your bail?
Lord,
from a hotel, my lord.
it is from a hotel, my lord. My lord, page 31, my lord, perusal of the case diary, prima facie reveals, my lord. I didn't start that. Now, my lord, by the same order, my lord, the co-accused Mohit Borovia's case was rejected and lordship disposed the bail petition, my lord, page 32. Page 32, my lord. 31/7/2025.
Yes, Mr. Parash.
He is not.
2.5 kg.
He is not related to that hotel, but he has the market shop in that market.
Heard Mr. J. Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Ainul Haq Laskar, who is apprehending his arrest in connection with Algapur PS case number 37/2025 under section 325/3 within bracket 5 of BNS. Added section 196 within bracket 1 within bracket B of BNS. Read with section 13 within bracket 1 of Assam Cattle Preservation Act. Just quote para 3 from page 33. Learned counsel for the petitioner has submitted that petitioner is in no way connected with the hotel from where the suspected beef meat was recovered. Stop. He also submits that the petitioner is an innocent person. However, police is searching for him in connection with this case. Learned, he further submits that the suspected beef meat has already been recovered and seized, and the petitioner is ready to cooperate in the investigation. Therefore, he prays that the petitioner may be granted anticipatory bail. Stop. On the other hand, learned additional public prosecutor has prayed for calling of the case diary and objected to the grant of any bail, any anticipatory bail at this stage. Court para 6. Now, before that, it appears from record that one of the co-accused, who is the proprietor of the hotel from where the suspected beef meat was recovered, has already been granted anticipatory bail by this court on 31/7/2025 in AB case number 1803/2025. So court para 6. 6 अलग changes over my episode. You appear before the IO within 7 days. If you appear, then 30,000 with one surety. The anticipatory bail application is disposed of.
Item 6.
May I, my lord? The 482 application, my lord. Here is two petitioner, my lord. One is my lord gynecologist and number two is my lord wife.
This FIR malad earlier malad some few 6 cases were malad already filed malad.
And your lordship granted interim, my lord. Case 31.
Location. When fiction malad 20th of August.
When it is fixed,
20th of August malad. By going by the FIR malad
okay.
এটা doctor আবেদন
Heard Mr. M. Kolita, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely Dr. Simanta Jyoti Tai and number 2, Srimati Manashi Barua Tai, who are apprehending their arrest in connection with Moran PS case number 75/2025 under section 61 within bracket 2/64 within bracket 1/98 of BNS, read with section 6 of POCSO Act 2012 and section 81 of the Juvenile Justice Care and Protection of Children's Act. Added section 143 within bracket 4/212 within bracket A/212 within bracket B/238/336 within bracket 2/340 within bracket 2 of BNS, read with section 80 of Juvenile Justice Care and Protection Act 2015. How you are connected with this?
Yes, my lord. Case 5 para 4, my lord. I have mentioned.
Yes. Read out.
The accused petitioner stated that accused petitioner number 1, Dr. Simanta Jyoti Tai, is a renowned gynecologist and obstetrician and is associated with Kayaking Healthcare located at Dimu, Shivsagar. Petitioner number 2, Srimati Mansi Barua Tai, is the wife of accused petitioner number 1 and also serves as a director of Kayaking Healthcare Dimu. The present petitioner are in no way connected and alleged offense mentioned in the affair. Furthermore, the petitioner has no connection whatsoever with promoter, diagnostic and hospital limited.
Then why are you
Yes, my
apprehending
lord.
arrest?
My lord, later part, my lord. Further, it is said that on 05/05/2025 in the evening, the victim girl came to the medical chamber of accused petitioner number 1 at Kayakan Healthcare, Osumari, Dimu for the first time. Accordingly, accused petitioner number 1 being a gynecologist.
Are gynecologist?
No, my lord.
Who is
She
to
is director, my lord, of Kayakin Healthcare.
petitioner number 1 is a gynecologist, whereas petitioner number 2 is the director of Kayakin Healthcare located at Limo. And they are in no manner connected with the offense involved in this case. He submits that both the petitioners were issued, both the petitioner had received notice under section 35(3) of BNSS in connection with the aforesaid case, and they have complied with the said notice and appeared before the investigating officer. However, now how they are threatening?
Investigation officer, I have mentioned, my lord, investigation officer visited, my lord, page 8, para 9, my lord. Page 8,
How?
Yes, my lord, investigation officer of the case visited the hospital where the petitioner are employed and allegedly threatened that the doctors and nurses.
Learned counsel for the petitioner has submitted that in spite of that, the petitioners were threatened by the investigating officer that they may be arrested in connection with the aforesaid case. And therefore, they have approached this court by filing this instant anticipatory bail application. Learned counsel for the petitioner has also submitted that in a connected case filed by some of the co-accused, the court has called for case diary and fixed the said case, that is within bracket applicable, AB case number 1778/2025 on which date?
On 20 August.
On 20th August 2025. Hence, learned counsel for the petitioner has also prayed for fixing this case on the said date after granting interim protection to the petitioners. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Stop. Let the case diary be called for. Let this case be listed along with AB case number 1778/2025 on 20 August 2025. In the meanwhile, considering the submissions made by learned counsel for the petitioners as discussed in foregoing paragraphs, stop. The above named petitioners are directed to appear before the investigating officer of Moran PS case number 75/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with the above noted case, they shall be allowed to go on interim bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2, list accordingly.
Item 29 from supplementary list.
Wait, please, your lord. There is a 482 BNSS application. The FIR will also be find at page 10. The page 13.
Yes,
Lordship, the petition, there are 3 petitioners in this matter. Out of 3, your lordship, they are named with the FIR.
they are named.
They are named in the FIR. 2 have been arrested, your lordship, already. And these 3 have not been arrested till now, and they are apprehending arrest. Sir, your lordship will kindly take page 13 for the FIR.
Case diary would be required.
Only one thing,
Let me pick up for a moment. Page 16 on the forwarding report. I'll just read two paragraphs on the grounds of arrest. That is at page 16.
Yes.
The grounds of arrest party. The first one on so and so date at around so and so, the accused person along with 7, 8 associates trespassed to the residence of so and assaulted so and so allegedly due to their interfaith relationship. At the house of so, accused person and his associates also physically assaulted so. Subsequently, the accused and his group possibly took the victim to so, during which they were physically assaulted on the road. Now, your lordship, during the assault, arrested accused person named so inappropriately touched so and allegedly to check if she was wearing undergarments. Additionally, so and his team reportedly attempted to force the victim to remove clothes and so physically assaulted so. Now, in fact, your lordship, with regard to these, there were 5, 7, 8 persons were there. These 2 persons were arrested were actually the family relations of the complainant. And these 2 persons have taken the other persons along with them to the house of that particular man, and from there they recovered both of these lady and they brought them to an office of I think it is AB or yes, ABMS, and these things have happened in the office, your lordship. Now the part of assault part, your lordship, that obviously I cannot say exactly, but with regard to the clothes and other things, specifically the police have stated that these 2 persons are the mastermind and they have directed these persons. And in these grounds, your lordship, the other 3 persons' name were not taken. That is why they have
No, because the grounds pertains to the arrested persons.
But
Case diary
even
would,
they have not stated anything. Other persons were also.
when can you produce the case diary? Heard Mr. Y.S. Manan,
20.
learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Considering the nature of accusation made in the FIR against the petitioners, perusal of the case diary would be necessary for consideration of the instant bail anticipatory bail application. Hence, call for the same. Please this matter. 21(8).
30 from supplementary list.
That hospital matter, just now Lordship has passed the matter. Now the petitioner before Lordship is a receptionist of that hospital. Even he has been called and Lordship.
Item number, along with item number, this 6.
Where is the bail order?
Lordship, the bail order is at page 71.
Heard Mr. S. Sharma, learned senior counsel assisted by Mr. A. Gautam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Hari Narayan Datta, who is apprehending his arrest in connection with Moran PS case number 75/2025. Baki item number 6 or case. The case details from item number 6 logo. The gist of accusation in this case is quote para 3 from page 71. Learned senior counsel for the petitioner has submitted that the petitioner is working as a receptionist in the Brahmaputra Diagnostic and Hospitals Limited in Dibrugarh, and he is in no way connected with the offense alleged in the FIR. However, he has been threatened by the investigating officer of the aforesaid case that he will be arrested in connection with the said case. Learned counsel for the petitioner has submitted that one of the co-accused, no, some of the co-accused have approached this court in connection with the same police station's case apprehending their arrest, and they were granted interim protection on 28/7/2025, and their cases are fixed for case diary on 28/2025. Learned senior counsel prays for fixing this case also along with the said cases, and prays for grant of interim protection with the present petitioner. Learned additional public prosecutor, on the other hand, prays for calling of the case diary. The prayer is allowed. However, in the prayer is allowed, let this matter be listed on 20 August 2025, along with AB case number 1778/2025. Then quote para 10. Quote para 10 from page 72 of the bail application. 30,000 within 7 days you appear, 30,000 with 170.
Bail hearing here, item 7.
May I please your lordship?
Yes,
Lordship, the petitioner is behind the bar for last 4 years, 7 months and 17 days, lordship. Lordship will come to page number 34. Page number 34.
what is your date of arrest?
Date of arrest was lordship 5/11/12/2020, lordship.
Yes.
So, lordship,
At what
page
stage
number 34.
what stage, page number 34? At what stage the case is pending now?
Lordship, as per record, is to 2 witnesses examined, lordship,
Out of
out of perhaps 6, lordship.
what perhaps? You must know. Out of 10.
Okay, sorry,
Yeah.
lordship.
You have to be ready with facts. It is your case.
Lordship. Out of 10, lordship, as per record, it's 2 examined. And lordship, these 2 witnesses, lordship, out of that, the first accused, lordship, Jalman Singh, granted bail, lordship, by your lordship. And may I
Very-
place the order, lordship?
Where is the bail order? Page?
Lordship, I'm placing it.
Yeah. Yes, what is the submission?
Lordship, I was co-driver, lordship. The owner and driver both were granted bail by your lordship, and lordship, I'm relying on lordship Ravi Prakash.
What is your submission?
Truck. And lordship, final complaint filed on 7/6/21, lordship. And lordship, after that, till 2023, lordship, status of the trial was production and appearance because one of the co-accused was absconded, lordship. That is why. Then lordship, charges frame on 30/11/23. So lordship, till now, lordship, 5 witnesses have been examined
Out of?
out of 10. This is the status of the trial, lordship. And they have stated that the co-accused will granted lordship, but nothing was recovered from him.
So I was co-driver.
And
Co-driver,
after that, after this order, lordship, one of the co-accused, lordship, he was also inside the truck, lordship, Jalman Singh. His bail was rejected by the Honorable Justice, lordship, Martin Nandi, lordship.
His bail was again, second bail was filed, lordship, and on 16/7/25, lordship granted him bail on spirit trial, lordship.
So lordship, now witnesses are coming, lordship. And next.
But
there is
even at that
12
stage
by
also, lordship.
25.
This is not the way to make submission. When she is submitting, why are you interrupting?
Bola di, lordship.
Yes,
So Lordship, this is my humble submission, Lordship.
Mr. What is your name? Mr. M. Rahman, learned counsel for the petitioner. Also Mr. M. Deka, learned additional public prosecutor. This, learned counsel for NCB. This application under section 483 of BNSS has been filed by the petitioner Jora Singh alias Tinku, who has been detained behind the bars since 5/11/2020, within bracket for more than 4 years, 7 months, in connection with special NDPS case number 23/2021 under section 21C/29 of the NDPS Act 1985, pending before the Court of Learned Sessions Judge Kamrup, Amingaon. The gist of accusation, quote from Court Para 3 from bail application number 1707/25. Record হতে আছে। Learned counsel for the petitioner has submitted that the petitioner was the co-driver of the truck from which the contraband was recovered. He also submits that the petitioner has been languishing behind the bars for more than 4 years, 7 months, and till date, only 5 out of 10 listed prosecution witnesses have been examined. He also submits that at the pace in which the trial is now progressing, there is an unlikelihood of trial being completed expeditiously. There is unlikelihood of early culmination of the trial. So he submits that the Court Para 5 from the judgment, instead of 4 years, 6 months, mention 4 years, 7 months. Learned counsel for the petitioner has also submitted that in the meanwhile, the other co-driver who was also present in the truck, same truck from which the petitioner was apprehended, namely Jhalman Singh, has already been granted bail by this court in bail application number 1707/2025 on 16/7/2025. Court Para 8 from yet mark kora ase. On the other hand, Ms. M. Deka, learned counsel for NCB, has opposed the grant of bail to the petitioner Stop. She has submitted that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable in this case. She also submitted that after filing of the final complaint in the year 2021 till the year 2023, the trial could not commence as one of the co-accused was absconding and his attendance could not be procured before the trial court. She submits that now only 5 witnesses are remaining and they are likely to be examined very soon. Stop. She also submits that the contraband were seized from the conscious possession of the present petitioner, and therefore she opposes the grant of bail to him. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of special NDPS case number 23/2021. Code para 12, 13, 14, 14 period to change over. Mark kore this. 15. Sixteen. 17, 18. 19, 20, 21. What was the contraband?
19,984 considered protein based cough syrup.
With 1,22,000, 1,00,000 with 2 sureties of lichen.
Item 8.
This matter passed over for timing. My senior counsel that number is on another case.
You are seeking adjournment or passover.
Passed over for time.
We'll take it apart. You furnished a copy of the petition, bail application. So. What should we do?
He has not done from another.
Yes.
Short that can be fixed.
Yes. What is your name?
Sorry.
A.
Sorry.
A. Shariful.
SHORI.
Sharif. Heard Mr. A. Sharif, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, as well as Ms. M.K. Brown, learned amicus curiae. For respondent number 2. Learned amicus curiae submits that she has not yet received the copies of bail application along with annexures as was directed by this court in its last order. Stop. The petitioner is directed again to furnish the copy of bail application with annexure to the amicus curiae, learned amicus curiae, during the course of the day. Let this case be listed on Tuesday, 12th.
Item 9.
This is an application under 483 BNSS law. The petitioner was arrested under section 20B2C, 29 of NDPS. Your Lordship. He was arrested on 13/9/2024, 11 months ago. Your Lordship, there are 11 listed PWs, 3 examined till date. I have enacted the PW's examination. I'll take your Lordship to that date. Your Lordship, basically this case is a ganja was recovered, 43.34 kgs of ganja was recovered from one house of one Rajiv Bormon. And the petitioner, Hirojyoti Deka, was in fact present in that place on that day, Your Lordship. On that ground, he was arrested, Your Lordship. The ground that he has come over to his place to purchase the said ganja. That is basically the case against the petitioner. Now, my ground is that no ground of arrest in the arrest memo has been provided to the petitioner as far as section 47 of the BNS. And your Lordship, I'll take your Lordship to that page 38. Nothing is given in this case. Page 38 is the memo. This is a very simple, Your Lordship, name, case number and all. Nothing, not a single.
No, notice, where is notice under 47?
Second is page 39. Your Lordship. This notice was given to the guardian. And as per the instructions, that is stated that no notice has been given. I don't know, but as per my instructions, it has not been given. And this is the exit. One more thing, Your Lordship. From the PWs, Your Lordship, page 31, there were 3 PWs were examined. Page 31, Your Lordship, PW 1, 2, 3, all are independent witnesses, scissor witnesses. And these 3 witnesses, Your Lordship, if I go through and read that, then Your Lordship, nothing is there from them.
No, it will not help you now.
That may not help me now, but I'm just pointing it out because these 3 scissor witnesses have, independent witnesses have just mentioned that they were present in the place of occurrence and they were asked to put the signature in the particular document and paper by the police personnel and nothing else. They have not seen from whom the ganja was recovered, and only when police personnel saw them coming, they were asked to put the signature. This is basically all the 3 have stated more or less the same thing. And with regard to the ground of arrest, Your Lordship, the arrest memo has been annexed. And earlier, Your Lordship, this matter was came up before this honorable court, and that was before the filing of the charge. And after filing of the charge sheet, the court has asked the petitioner to approach the authority for regular bail before the court, and that was disposed of. So this is after the charge sheet. The regular bail was rejected by the trial court. The rejection order is at page 30. Well, not page 30, page 34. Page 34. This was rejected on 6/6/20. Therefore, thereafter that. Now, with regard to whether the arrest memo has been provided or not, that has not been annexed. So my learned friend will be in a better position.
If Lordship kindly takes up the scanned copy, I have flagged on the 47 notice. Grounds are there. Furthermore, I can also propose this. Yes. Found it. Furthermore,
Oh, yes.
and furthermore,
Yeah.
Lordship kindly takes up their petition also, the order dated 6/6/25. Whereby they prayed for bail, Lordship. There also the learned court below has recorded its satisfaction Lordship, in paragraph, in page 36. Page 36 of their bail application, if Lordship kindly take up. This is order dated 6/6/25. Page 36 is the relevant portion. Middle portion Lordship will find. On perusal, the case record, it appears that on 13/9/24, the accused Hirokjyoti Deka, that is the petitioner, was arrested in connection with so-and-so, under section so-and-so, with two other accused persons. On that day, the investigating officer issued an arrest memo, inspection memo, grounds of arrest, and reasons of arrest to the accused in writing. The accused put his signature on the above mentioned arrest memo, and Ankita Deka is the wife of the accused, and she was also informed of the arrest of the accused. So and so. Now, Lordship, regarding Lordship, the PWs, in the meantime, Lordship, 5 have been examined. On PW 4 was examined on 31/5/25, and PW 5 was examined on 10/7/25. And altogether, Lordship, 11 PWs are there. So 5 have already been examined. The trial is going on at a rapid pace, Lordship. So at this stage, this may not be entertained.
Heard, Mr. Y.S. Manan. Your main plea is that 47 was not complied with.
Yes, that was my instruction. I am going by my instruction. That is why I referred, whether that has been given or not will be, my friend will.
Also
better
had
position to it.
Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Hirokjyoti Deka, who has been detained behind the bars since 13/9/2024, within bracket, for last 11 months, bracket close, in connection with special NDPS case number 4/2025 under section 20B2C, 20 within bracket small b, within bracket small Roman 2, within bracket capital C, /29 of NDPS Act 1985, presently pending before the Court of Learned Special Judge Borpeta. The gist of accusation in this case is that on 12/9/2024, one Bhaskar Bora, SI of police, had lodged an FIR before the officer in charge of Borpeta Police, Sarthebari Police Station, Inter alia, alleging that on receipt of an information regarding illicit illicit transportation of suspected ganja, illicit storage of suspected ganja at one house situated in Bengapara under Sarthebari Police Station, a police team was constituted and the suspected house was searched. During search operation, 3 accused persons, including the petitioner, were apprehended therefrom, and from their possession 43.340 kgs of suspected ganja was recovered and seized. Stop. Learned Mr. Y.S. Manan, learned counsel for the petitioner, has submitted that the petitioner has been languishing behind the bars for last 11 months, and till date only 5 out of 11 prosecution witnesses have been examined. He submits that PW 1, 2, and 3, who are the Caesar witnesses, have not implicated the petitioner in the offense alleged in the FIR. Stop. He submits that the petitioner has approached this court seeking bail mainly on the ground of violation of his violation of his fundamental rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India, inasmuch as no notice under Section 47 of the BNSS was served on him, and he was not communicated with the grounds of arrest, in writing, at the time of his arrest. Stop. Learned counsel for the petitioner therefore submits that in the aforesaid circumstances, the petitioner is entitled to get bail. Stop. On the other hand, learned Mr. B. Sharma, learned additional public prosecutor, has vehemently opposed the grant of bail to the petitioner at this stage on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore, the embargo of Section 37 is applicable to this case. He submits that in he submits that the petition, he submits that only 5 witnesses have already been examined in this case, and 5 more are yet to be examined. 6 more are yet to be examined. Stop. He further submits that in this case, the petitioner was served with the notice under Section 47 of the BNSS at the time of his arrest, and said notice mentions the basic facts which necessitated his arrest, and therefore it is in compliance with the constitutional mandate of furnishing grounds of arrest in writing to the petitioner at the time of his arrest. He therefore opposes the grant of bail to the petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the materials and on record. Stop. Next paragraph. In this case, 5 witnesses are yet to be examined, and at this stage, 6 witnesses are yet to be examined. And at this stage, this court cannot pick and choose the evidence available now for considering the bail application when 6 more witnesses are yet to be examined. Stop. As regards the plea of the petitioner that his fundamental rights guaranteed to him under Article 22(1) is violated in this case, it appears that the notice served on the petitioner on 13/9/2024, that is on the date when he was arrested, does mention the basic facts and the accusation against him so as to intimate him about the grounds of his arrest. This court is of considered opinion that the form in which the notice was served on the petitioner and the content thereof are in compliance with the requirement of section 47 of the BNSS as well as constitutional mandate provided under Article 22 of the Constitution of India as 22(1) of Constitution of India as clarified by the Apex Court in the case of Bihan Kumar versus State of Haryana and others reported in 2025 5 SCC 799 stuff. For the aforesaid reasons, this court is of considered opinion that the petitioner has not been able to overcome the embargo of that section 37 of the NDPS Act in this case, and accordingly, he is not entitled to bail at this stage. The prayer for bail is therefore rejected.
Replies the charges to framed on 5/3/25. That may be applicable.
Not necessary. Because he's pressing mainly on 47 notice.
His contention was that he has been in custody for 300 something days. So that.
No. 11 month only.
11.
11 month. So that I have not discussed.
Item 10.
Negligible. In this case, you already, this petitioner minor, he was custody in connection with Mia case. That is Mia case number.
Near case number
Mia case number 2 of 2029, 2019, man. He was arrested, my lord, on 18/5/2019, my lord.
when?
18/5/2019, man.
18/5/2019.
And thereafter, my lord, he was released on bail on 9/6/2029. The order was passed on 9/6/2025, my lord. And he was released from custody on 10/6, my lord.
Yes.
While he was released from the jail authority, my lord, on that day he was picked up by police, my lord. By the local police station, my lord, at Bosiswar. From there he was taken to Tongla. From Tongla, my lord, he was soon arrested in another case, there is Tongla PS case.
In which jail you were detained?
District jail Guwahati, my lord.
Yes. So you were picked up from district jail Guwahati
Guwahati
and then taken to Tongla police station.
police station, then I was taken to Tongla.
Okay.
And I was produced before the special judge, Tongla, Udalguri, in connection with this Tongla PS case number 59 of 2020. And in the foreign report, they have stated, my lord, they stated that it was page 48, my lord, your lordship will find that Chinmoy Law Court, so is a hardcore alpha cadre having associated with a banned extremist alpha, was previously arrested and forwarded to judicial custody in connection with RC case number 4 of 19, registered under section, that is case under Niyam, RC case. So they have admitted that I was in custody. During investigation of the case, it has found that while the key mastermind of the case, Jumon Bora, was in the process of raising a new armed extremist outfit in the name and style Revolutionary Front of Greater Assam. He was in touch with a veteran alpha leader, Chinmoy Lahore and Vijay, who were lodged in the central jail. Chinmoy Lahore and Vijay criminally conspired with Jumon Bora. In furtherance of the criminal conspiracy, they informed Jumon Bora that 2 crores of cash collected by Alpha by means of ransom were kept concealed in Nagal forest in Sibsagar district. Further, as per our instruction of Jumon Bora, and launched a search operation in the said forest in August 2024. Chinmoy and Vijay were planning to use this cash to procure arms and ammunition for RFGA using their alpha contacts. Chinmoy and Vijay were providing outside support to RFGA.
What is your name?
My name is Sinmay Law.
Chinmoy.
Sinmay.
Okay.
I'm planning to do so and so. Now it's important. Number 3 is very important. Vijay come where although laws in jail maintain a clear license with Jumon Bora, either through physical visits of Jumon Bora to the central jail or through SMS phone calls. This shows that Vijay and Chinmoy Law were very clear about RFGA giving it the identity friends. Now, my first option before you all, first of all, he is in district jail. I being arrested in case of Myanmar. So I was segregated from ordinary prisons. Even my parents, well, I made a statement in my petition also that whenever our parents used to visit, we used to take permission from the Nia court for meeting my son. Otherwise, they don't allow it. That is paragraph 13, man. That paragraph 13, we have to, otherwise they don't allow it. So question of meeting any other person doesn't arise at all, man. Unless there is a conspiracy with the jail office. If there is a conspiracy, that matter would have been different. Otherwise, no person can directly meet me. Because I'm segregated from other prisons. So that statement is not correct, my first person. Second question is that they are saying that SMS and phone calls, where the call records are there. Is there any call records seized? How can I use a mobile phone inside a jail? I should be connivance with the jail officers. That's quite impossible. Whether call records has been seized or not. Nothing is there, man. So my humble submission, the allegation that has been made in the forwarding report is based on surmise and conjectures. There's no material, corroborative material to substantiate. So, prima facie also, for purpose of section 41D, that your lordship will language that has been used, lordship mechanism.
Unlawful activities.
That you'll also find that 43D, subsection 5. Because I was charged under section. So far as section 18 is concerned, unlawful activities prevention. Section 18 falls under chapter 8. That is a conspiracy. Section is whoever conspires or attempts to conspire, abets so and so, commission of a terrorist act or any act perpetrated to the commission of terrorist shall be punishable with the imprisonment for term which shall not be less than 5 years, may extend to imprisonment of life, shall also liable to be fined. But one thing is important, my lord, in this case. If I made a conspiracy, that what is the conspiracy to cause for commission of a terrorist act? So what the terrorist act, but no other offense under unlawful has been registered. Only 18. So conspiracy to what is the terrorist act that has been committed? That should be a substantive offense to that effect. No doubt 18 is a substantive offense. So commission of the terrorist act, there ought to have been another section. That is not whatever it is, but it falls under chapter 4. Now, if it falls under chapter 4, then your lordship will kindly come to section 43D, subsection 5. Notwithstanding anything contained in code, no person accused of offense punishable under chapter 4 and 6 of this act shall, if he is in custody, be released on bail or on his own bond, unless the public prosecutor has given an opportunity of being heard of the application of such release. Provided such person shall not be released on bail or his own bond if the court on perusal of the case, the report made by under section 173 of the code is of the opinion there are reasonable grounds for believing the accusation of such person is prima facie true. So, first of all, the satisfaction of the court is that whether the allegation that has been made are prima facie true or not. So, the accusation is made, that accusation is that one of the co-accused made me the jail. And I had SMS and phone calls with that accused. That is the material. Their conspiracy is that. Based on that material, they have developed the story. Now, whether the call records are there, because without a permission, I cannot go. He cannot meet me. The typically entry has been barred under the jail menu because I am involved in a NIA case. So, considering the
Yes, then you would reveal that.
just I'm begging myself. I don't know what is there in the case.
Yes.
That apart, because of Sheikh Abdullah's case, because knowing fully well that I am in judicial custody in another case,
is it not the duty of the prosecution to inform the court that a case is pending against him in connection with, because from the materials that is from the forwarding report, it appears that in the year 2024, they know it, that there is a case of conspiracy has been made. If that is so, so my rights has been also been violated under Article 21. So, there you say that paragraph 5, my lord, of the judgment, my lord. We are quite amazed at the statement that we should have expected if not the order of bail is
Which judgment? Abdullah.
Abdullah, paragraph 5. Mr. Kakka said that petitioner were enlarged on bail in pursuance of the order passed by this court.
No, you are reading which paragraph?
Para 5.
But it states something else.
No, para 5 of Udechan versus this.
Yes, it starts with Miss Kakar.
Kakka, yeah. Kakka stated before us the petitioner were enlarged on bail in pursuance of an order passed by this court on 2/3/1981. But they are subsequently arrested for some other offences alleged to have been committed by them prior to 2/3/81. We are quite amazed at this statement. We should have expected, even after the order of bail passed by us, the authority of the state considered fit to arrest any petitioners for any other offence. It is their bounden duty to apprise this court before taking this person into custody, especially when no disclosure was made to us when we passed the order of bail that any case or cases were under investigation against any of the petitioners. We regret that this elementary courtesy of this court was not so. We would like to reiterate, prisoners shall be treated as free citizens in spite of the fact they have been subsequently arrested with arrests which are clearly contrary to the order of the bail by this court. And this judgment might be relied by our High Court in common doctor's case, my lord, that is Justice Guya, my lord. That is 2015 PJL 346, my lord. There also it states, my lord.
Which para?
Para 24. In Uday Chan versus Sheikh Mohammed so and so, the Apex Court deprecated the practice of withholding information from the court about the requirement to arrest the accused in other cases. It was held that even after the order of bail is passed by this court, the authority of the state consider it fit to arrest a released person for any other offence. It is their bounden duty to apprise the court before taking the person into custody. In the facts of the case, the arrests were held to be contrary to the bail order passed by the Apex Court. Accordingly, the petitioners were being released from custody, retained to be free citizens. Having regard to the above, the court is of the view the accused upon class should have been released as a continuing detention has become clearly untenable. As above, he has been granted bail by this court out of 4 cases, that is so and so, so and so. He now shall be released on bail in connection with other 3 cases, subject to the condition he shall cooperate with investigators. And another important fact, my lordship may kindly see. In the foreign report, they say that I was in contact with while I was in custody in case of a NIA case. Is it not the duty of the officer to inform the NIA court that after all it is a judicial custody? Trial is going. This is my bail condition.
Suppose there is breach of that duty by the police.
Yes.
What right has been violated?
Yes, because my right of information, my lord. I am entitled to know because I am in custody in another case, in a NIA case. And there are conditions in a NIA that I should not, because there are stringent conditions are there. Even I have violated conditions. It is not the duty of the investigating of the inform that court that he made a conspiracy while he is in jail, man. Because I was custody in that case, man. Out of blue, when I was released on bail, they arrested me. If it is a case of conspiracy in the year 2024, why they have arrested me on 25, man? They could have informed the court, man.
Yes, he should have or could have informed the
Yes,
court.
that's why they are
But
arrested.
both the judgments which you are relying
Yes.
on, the Sheikh Abdullah as well as Kamal Datta, do not say that it violates the fundamental right.
Violence, but that is the principle of law that has been stated by law. In a pending case, it's a duty of the
Yes.
prosecution. to
Now
inform
my
the-
query is, suppose that has been done in a case where there is embargo 43D5.
43 also may kindly see there another important aspect. I'm in custody in a NIA case. Lordship may care. Trial is going, witnesses were acted. Now, while I'm custody in NIA case, It is the case of the prosecutor. I have indulged in conspiracy with another accused from outside while I was in jail. Thereby, I have violated the bail condition. Your Lordship, my lord, is it not that the duty of the investigator to inform that court, my that while he was custody, because there are restrictions for movement inside my jail, my I cannot go outside, I cannot talk to anybody, not to say about phone calls. So out of nowhere, they're making a story which is quite unreasonable, but unbelievable. And
Had you been informed, you could have gone for file an anticipatory bail application.
whatever, their record will speak itself, whether they're actually, because the ground that there's
No, no, is that your submission that in that way your fundamental right?
that's why my right has been taken, but there's a non-existent grounds. The grounds stated in the is report totally non-existent. It cannot be possible. Court is looking after it. They have, for each every inspection, I have to take permission. My
No,
parents have to take permission
no.
to meet me. How this
Oh,
is possible? That
What I want to understand is,
yes,
as in this case, there is a statutory embargo,
I understand.
43
D.
D5.
Yes.
So unless there is violation of fundamental right,
Fundamental rights is because my right to for previous bail has been also been deprived by.
if there is a breach of fundamental right, that
Yes.
then that statutory
I
embargo
understand,
may be.
because here
But your submission is that there is a breach of
fundamental rights, madam. rights.
duty on the part of.
By rights too, because I could have closed the court out of 438. If I knew that there is a case pending against me. Because even in
So
custody,
by not informing you,
I was deprived from exercise by legitimate rights, man.
okay,
Because I could have exercised power under 438.
okay,
That that there is no case against me, or I'm entitled for PRS bail.
okay.
And even then 433 applies also. Actually, my prima facie, your lordship will find there is no material, cannot give any material, because unless and until there is a phone records, or because it's quite impossible to meet a person inside jail who is in custody in years without the permission of the jail authority. Then the jail authorities have to be part of the conspiracy. Otherwise, it is quite impossible.
Okay. Yes, Mr. Das.
Firstly, I want to state it, dear lordship, the two citations that has been relied upon by learned senior lordship. It is it comprehends a complete different facts and circumstances, lordship. Here the facts and circumstances are different. So a complete gray area has been created, lordship, in which this facts has not been covered. Firstly, I want to state here, lordship, in this case, as my learned senior has stated that it is a NI case, lordship. And this is a police station PS case, lordship, Tongla case. If I look into the Kamal Datta case, lordship, if I look into page 20, lordship, kindly look into it, lordship.
Yes.
Here, all the cases, case number 1 allow, PS case number 07 so and so, Pasighat PS case so and so, Basar PS case so and so, Itanagar PS case so and so. But in this case, completely different agency. One is a national agency, lordship, and another is a state agency. There may not be any coordination, there may not be, lordship. So in the
No, therefore, what you want to say?
Therefore, I wanted to state that this citation does not cover these facts. The present facts and circumstances of the case does not cover, lordship.
No, no. Do you want to say that the state police were not aware about pendency of NIA case?
No, lordship, NIA may not be aware of the NIA agency. No, lordship, NIA may not be aware, because if NIA agency wanted this person for another case of them, lordship, then it is a different case. They don't want this petitioner in their bail petition, lordship. They did not want this petitioner for their investigating in by themselves, lordship, in another case. This is another agency, lordship. And in what I can humbly state that, lordship, what in the forwarding report, the police authorities have aware of it. So they have in the forwarding, lordship, they have well written that this case has been pending. It is not if it is their duty, lordship, they have aware. So they have acknowledged this to the court, lordship. In the court order also, lordship, I have found it has stated that so and so cases has been there. Court order also.
Which court's order?
In the next PS case, lordship, this Tongla PS case, in that order, remand order, Lordship. In the remand order. it
No,
is
no.
stated,
First of all,
Lordship.
his submission is that as the petitioner was detained in Nia case,
Lordship.
therefore, by virtue of this Sheikh Abdullah's judgment,
Lordship.
if another case is also pending during his detention, that is the subsequent case in which he was arrested after his release, Nia should have informed the court in which he was earlier detained, that a separate case is also pending against him. This is your submission. Yes.
My submission. Lordship, my submission is that if the bail granted in the first circumstances, Lordship, it is in the case of Nia case, Lordship. So if I look into the citation, Lordship, then it is the duty of the Nia, Lordship, because they were investigating that case. We are already informed in our case that this is case, but Nia may not be aware of these cases because it is completely different agency, Lordship. This is a national agency, Lordship. Central agency, Lordship. This is a central agency. They may not aware. And in this CD, I cannot be aware of it, whether they are known or not known, there are cases pending in this case, Lordship. In this CD, from reading this CD, I cannot be made aware that whether the NI is aware of this case or not, Lordship. But we are aware. As in this Tongla case, we are aware of this. So we have informed, as our duty, we have informed to the court, Lordship, that this case is pending. But that is related to NI case, Lordship. We can be directed that our wrong, Lordship, if we have not been, if we are aware and we have not informed to the court, but we are aware and we have informed, that is a NI case, Lordship. They may not aware.
Okay.
That is my submission, Lordship. Moreover, as this is a, Lordship, 43D embargo comes here. Here, Lordship, it is different as embargo is there. So prima facie, if materials is sufficient. And whether in this materials, Lordship, what I can want to state here, Lordship, criminal conspiracy is also added. That is on 11.6. Court has allowed 6122 within bracket 2A. That is a criminal conspiracy. That has been added, Lordship. And moreover, the role of the accused, that is, Lordship, he has conspired with the other persons in forming a outfit, Lordship, that is Revolutionary Front of Greater Assam, Lordship. And what he does, he also been aware of 2 crore rupees, which has been received through extortion, Lordship. Moreover, Lordship, SMS is also there. What is there in the records, Lordship? SMS between, I may read, Lordship. Further SMS between Suman Bora and Vijay Assam shows that Suman Bora had supplied objectionable items to Sinmoy Lohkar and Vijay Assam in Central Jail, so Lordship. And what are the materials are there, Lordship? The materials are such that, Lordship, which can be used for preparing a, Lordship, outfit of this organization, Lordship, terrorist organization.
What materials?
These are, Lordship, according to the CD, Lordship, 15 meters of some black colored cotton cloth, 20 numbers of black colored cotton cloth, and 50 numbers of black colored thread tool. Yes, it is true. It may be another purpose also. But as for the copy of the screenshot of conversations, it is there. Conversations are enclosed here. Conversations are also there. And their context is also there. That means, Lordship, a context is there. And for that context, this has been made, Lordship. So, in my humble submission, Lordship, I want to state that, Lordship, there are prima facie material. Whether there is a communication or not, that is a matter of trial, Lordship. Trial will determine. It is a trial matter, Lordship, whether these things are true or wrong. It will be determined at trial stage. But at this stage, Lordship, prima facie materials has been there, Lordship. In my humble submission, I want to state this only.
No, his submission is that Nia might not be knowing
Right.
regarding pendency of a
I understand, but
case by state police.
my submission will be the prosecuting agency may be different. but they know that it was in the near court. So it was a duty to inform the court, not the
Whose duty?
that
Nia's duty
no,
or
no.
Assam police?
Assam. No, they never informed the near court. The near court has been granted bail. So it was the near court, since the matter was pending before the court, they should have informed the near court that these are the cases pending against Swench.
Okay.
And regarding the SMS, there is no all little records. The SMS also records that should be there. There is no such records.
Okay.
Because they
I'll go through the case diary.
if the records are now there, they have to substantiate it because I'm inside the jail. Screenshot will not do. What point out those records?
No, those screenshots are between two other persons,
That not between me, man.
not with you.
So how I am
Vijay
impressed?
Assam and
Vijay Assam and this person also, Juman.
Juman is somebody
And
else.
That Suman has given this to this person,
Oh,
Lordship,
okay.
Chinmay Taluk,
Okay.
Chinmay Local, Lordship.
Mr. P. Kotoki.
Last point, Lordship.
Yes.
Another point, regarding this case cannot be equated with Bihan case, Lordship. As regards to
I'm not-
violation of.
He has
No,
not,
Lordship, no, Lordship, on that point, constitutional mandate has been violated. On that point, I am stating, Lordship. Because of this, Lordship, even if I've taken this, that maybe not there, the information may be with there, but it cannot be equated with violation of fundamental rights, Lordship. I only want to emphasize on that point, Lordship.
okay. Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Chinmay Lokar, who has been detained behind the bars since 10/6/2025 in connection with Tongla PS case number 59/2025 under section 5 of the Explosive Substance Act, read with section 18 of the Unlawful Activities within bracket Prevention Act 1967. Where is the FIR?
FIR, my lord. Please
The
continue.
gist of accusation in this case is that on 13/9/2024, one Hirok Jyoti Pegu had lodged an FIR before the officer in charge of Tongla Police Station, inter alia, alleging that an information was received through reliable sources that one hardcore criminal from Jorhat district, namely Juman Bora, having association with banned extremist outfit Alpha within bracket 1, Alpha within bracket I, is taking shelter in Tongla town with intention of arranging arms and explosive to raise a new armed extremist group. Accordingly, a police team was constituted and it left for Tongla town. During search of the suspected house, 4 accused persons, namely Rajiv Deka alias Tulsi, number 2 Juman Bora alias Amlan Bora, number 3 Pinku Seal alias Vivek Assam, number 4 Jintu Bosho alias Jintu Assam, were apprehended therefrom with one live grenade. Stop. Learned counsel for the petitioner, Mr. P. Kotoki. Next para hoga. Learned counsel for the petitioner, Mr. P. Kotoki, has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He submits that the petitioner was detained behind bars in connection with NIA case number 2/2019 since, what was the date of it?
18/5.
Since 18/5/2019. He also submits that in the said case, within bracket NIA case number 2/2019, he was granted bail on 10/6/2025. And after submission of bail bond, he was released from the Central Jail Guwahati on 10/6/2025. Learned counsel for the petitioner further submits that on his release, the police immediately apprehended him from the outskirts of Central Jail Guwahati itself and took him to Bashishta police station. Stop. From there, he was taken to Tangla police station and was shown and was arrested in Tangla police station, case number 59/2025, and was produced before the which court?
Before the special judge, Madam Tanglam.
Before the special judge Dorong,
Udalguri.
special judge Udalguri. Stop. Learned counsel for the petitioner has submitted that in the instant case, the manner in which the petitioner has been arrested, instant case of Vidibo, within bracket Tangla PS case number 59/20. Manner in which he was arrested was violative of the guidelines of the apex court issued apex court in the case of Sheikh Muhammad Abdullah, Chief Minister. No, in the case of Uday Chand versus Sheikh Muhammad Abdullah, Chief Minister of Jammu and Kashmir, reported in 1983 to SCC 417, as well as the observation made by this court in the case of Kamal Datta versus Union of India and others, reported in 2015 SCC Online GAU page 759. Stop. He submits that it was the duty of the prosecution, it was the duty of the state agencies to inform the NIA court when the petitioner was detained in NIA case number 2/2019 regarding the pendency of Tangla PS case number
Regarding involvement.
regarding the involvement of the present petitioner in Tangla PS case number 59/2025. Stop.
24.
2024, you have, okay, you have mentioned
59.
59/2024. God Bilakon. 2024. Yes. By not doing so, no, learned counsel for the petitioner has submitted that by not doing so, the petitioner's right of seeking pre-arrest bail or other appropriate remedy in Tangla PS case 59/2024 was infringed. He submits that in the case of Uday Chand versus state of, in the case of Uday Chand versus Sheikh Mohammed Abdullah, CM Jammu and Kashmir within bracket Supra, as well as in case of Kamal Datta versus Union of India, both the courts had treated the subsequent arrest of the petitioners in those cases after they were released in bail in connection with the earlier cases pending against them as illegal, and they were released from custody in the subsequent cases, treating them to be free citizens. Stop. He submits that in the instant case also, the proposition of, is it a proposition of law?
Yes, my lord, it has been relied by our High Court also, my lord.
Okay.
That whenever it is arrested in a case, if there are pending cases, it was duty of the
The
prosecutor.
proposition of law laid down by the apex court in Sheikh Mohammed, Chief Minister, in the case of Uday Chand versus Sheikh Mohammed Abdullah within brackets Supra, has been violated, and has been violated, which has resulted into violation of the fundamental rights guaranteed to the petitioner under Article 21 of the Constitution of India. Stop. He therefore submits that in case of violation of fundamental rights in view of non-observation of mandate laid down by the apex court in the aforesaid case of Sheikh Mohammed Abdullah, the embargo of 43D within bracket 5 of Unlawful Activities Prevention Act would not be applicable. Learned counsel for the petitioner has also submitted that the petitioner till the date of his arrest till the date prior to his arrest in Tongla PS case number 59/2024 was detained in district in the Central Jail Guwahati as a detainee against whom NIA case number 2/19 was pending. He submits that the under trial prisoners under facing cases under NIA Act, facing cases of NIA cases are not allowed to meet any outsider without the permission of NIA court. He therefore submits that the accusation leveled in the FIR, that accusation leveled against the petitioner in the forwarding, that the petitioner met Juman Bora, who is the named accused in the FIR, is not reliable. He also submits that as the petitioner was detained as a under trial prisoner in Central Jail, the question of using mobile phone or any contact with outside, any contact with extremists who were outside the prison through mobile phone or SMS is not,
That's not permissible as impossible.
is impossible. Stop. He therefore submits that in this case, there are no reasonable grounds to believe that the petitioner has committed offense under Section 18 of the Unlawful Activities Prevention Act. And hence, he submits that the embargo of Section 43D within bracket 5 of the NDPS Act is not applicable to this case.
Grounds are vague and non-existent.
He also submits that the accusation made against the petitioner are vague and non-existent. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner at this stage. He submits that the offense involved in this case, one of the offense involved in this case is under Section 18 of the Unlawful Activities Prevention Act 1967, which falls in Chapter 4 of the Unlawful Activities Prevention Act. And therefore, he submits that the embargo of Section 43D within bracket 5 is applicable to this case. He submits there are sufficient materials indicating to the complicity of the petitioner in the offense alleged in the FIR. And therefore, the petitioner has not been able to overcome the embargo of Section 43D within bracket 5 of the Unlawful Activities Prevention Act. He further submits that the facts of the present case are distinguishable from the facts of the cases relied upon by the learned counsel for the petitioner. He submits that in both the cases, namely Uday Chand versus Sheikh Abdullah Supra, as well as Kamal Datta versus Union of India Supra, the investigating agencies involved was the state police, whereas in the instant case, in one case, that is NIA case 2 of 2019, the investigating agency is a central investigating agency, that is within bracket National Investigating Agency. Whereas in the subsequent case, that is Tongla PS case number 59/2024, the investigating agency was state police. And nothing has been shown to indicate that that the National Investigating Agency was aware about pendency of Tongla PS case number 59/2024. And therefore, the state, therefore, the observations made in Uday Chand Supra as well as Kamal Datta Supra are not applicable. Therefore, he submits that the observation made in Uday Chand Supra and Kamal Datta Supra are not applicable to the instant case. This much.
There is no violation of fundamental.
He also submits that in this case, there is no violation of any fundamental rights of the petitioner, and therefore the embargo of Section 43D5 is applicable to this case, and hence he submits that the petitioner may not be allowed to go on bail. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Tangla PS case number 59 slash 2024, which was produced by learned additional public prosecutor. Stop. Give me the case diary. I'll go through the case diary. On Tuesday, heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. D. K.K. Das, learned additional public prosecutor. List this matter for delivery of orders on Tuesday on 12.
But may I be allowed to submit one citation? A copy of. I
Yes,
submit.
you take back the case diary today itself in the evening.
And I may be allowed to submit on case law regarding this.
What case? You have to inform the other side also. What case you are relying? No, after giving him a copy, you give me a copy, marking the paragraphs.
M11.
Wait, please, your lordship. This is a petition under 483 lordship. Activity is behind the bar for last 35 days. Since 5/7/25, he was remanded on the allegation that he is the owner of a unisex salon. And the affair was lodged by police officer with an allegation that he has procured some girls in the name of beauticians and utilized them for sex work. Mostly CD has come, lordship.
Yes.
What is your plea?
So here, I think that no allegation, the allegations as brought are totally false, lordship. No such, it is only purely a beauty parlor, lordship.
Where is the affair?
Affair is at page 12, lordship. At page 15, the copy. Lodged by TSI Kaushik
Who
Dole,
are you? What is your name?
Chiranjit
Chiranjit?
Brahmo.
You are the owner of the.
Yes, Lord. We are running the beauty parlor for last 1 year without any allegation, without any, we have a trade license for that.
What is your submission?
Lordship, the allegations has brought.
False.
False, Lordship. No such act. It is purely a beauty parlor. There are out of 4 women were recovered, according to the police. Working, 2 are full trained beauticians and 2 are trainee beauticians. Police has shown them as victims. Most probably their statements have been recorded.
So we'll peruse the case diary. Any other submission?
And the length of detention. It is for
How
35 days.
how much is the punishment?
For
What is the
370
statutory? Oh, 90 days.
70. 10 years, Lordship, practically in 370, Lordship.
64-1.
64 is raped. There is no allegations who was raped or who has committed the offense. Victim, neither the name of the victim is there nor no FIR by the victim. And some offenses are under the Immoral Traffic Act, Lordship. Those are punishable up to 2 years.
3, 4, and 5.
Yes, Lordship. In 2 cases, it is 2 years punishable. In 1 case, it is 3 years. Both 370 and Immoral Traffic Act. Normally, it could not stand together, Lordship. If the 370 applies, then the girls may be victims. The 4 beauticians, according to police. Then they cannot be under 345. If they are booked under 345, then they will also be co-conspirators. Then there cannot be 370.
$370 means 143.
Trafficking.
143.
370 IPS.
Yes, Mr. Sharma.
143 of trafficking. Another case is anticipatory bail for the second FIR named case. Item number 18. The same case.
Number 8.
That is still speaking.
We'll take item number 18 after this.
Bro.
Yes, Mr. Sharma.
Lordship will kindly come to the forwarding at page 17. present petitioner lordship, this is BA 2330, he is the owner of the parlor lordship. And lordship, the other accused person, he is the manager and also the wife of the present petitioner. According to the statement of the victim girl. Now,
Somewhere she has been engaged, termed as lover. She is not the wife.
now, lordship, in this forwarding, lordship will find all these details are given along with the name of the girl's lordship. And also lordship, second paragraph, lordship, kindly see, it is also revealed that Srimati Kangli Toimari, that is the other petition, is manager of the parlor, and Chiranjit Brahma, that is the present petitioner, are running the parlor where sex racket is being carried on. The Chiranjit Toimari was found absconded. The parlor owner Chiranjit Brahma was apprehended and his mobile phone was also seized, and he along with the said 4 girls were brought to police station for taking necessary action. During this search operation, it is revealed that beauty parlor was posing as a massage parlor, while in reality the owner and manager were allegedly coaching the girl for prostitution, so and so. Now, lordship, their 161 statement has been reported. They have implicated the present petitioner's lordship. And also stated that they used to take money that was being paid by the customers. They used to take a major share of that and paid a small share to the girls. That is the statement of the girls under 161.
They have given mostly 164 also. They have been produced before court lordship. So for our information, instruction is there lordship. The girls were produced before the honorable magistrate, let's learned magistrate for recording their statement are 164 lordship.
Yes, so I was coming to that lordship. Now in the 164 lordship, they have completely denied all this. They have said that no such activities took place. So that is the status of the case.
Oh, then your case falls flat.
Right now, yes, lordship.
Any other evidence is there?
No, lordship, there are some hearsay evidences, lordship, of the other.
Anybody seen?
No.
Seeing the
Heard, lordship,
heard
and
Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Shri Chiranjit Brahma, who has been detained behind the bars since 5/7/2025 within bracket for last 35 days in connection with Kokrajhar PS case number 164/25 under section 143/64 within bracket 1 of BNS, read with section 3/4/5 of the Immoral Traffic within bracket Prevention Act 1956. Stop. Next para. The gist of accusation in this case is that on 4/7/2025, one Kaushik Dole, SI of police, had lodged an FIR naming therein 2 accused persons, including the present petitioners, inter alia, alleging that the beauty parlor name by the name and style of Relax Unisex Salon located at RNB Road, Kokrajhar, owned by the present petitioner, has been engaged in sexual exploitation of young girls who are brought there from different part of Assam. It alleged in the FIR that a search operation, a raid was conducted on the in the said beauty parlor on 4/7/2025, during which 4 victim girls were recovered from the said beauty parlor, and the petitioner was apprehended and his mobile phone was seized. Stop. Learned counsel for Mr. S.K. Poddar, next para. Mr. S.K. Poddar, learned counsel for the petitioner, has submitted that the accusation made against the petitioner in the FIR are totally false. He submits that the petitioner is the owner of the aforementioned beauty parlor, and he has got trade license for the same. So he submits that the petitioner has been detained behind the bars for last 35 days, and he is ready to cooperate in the investigation, and therefore prays for allowing the petitioner to go on bail. On the other hand, an additional public prosecutor has produced the case diary of Kokrajhar PS case number 164/2025 and has submitted that though the victim girls whose statements were recorded under section 180 of BNSS had earlier incriminated the petitioner in the offense alleged in the FIR, however, while deposing before the magistrate under section 183 of BNSS, the victim girls retracted from their earlier stand and have stated that they are engaged as beauticians in the beauty parlor, and no incriminating statement have been made against the accused persons named in the FIR, including the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Kokrajhar PS case number 164/2025. Stop. On next para. On perusal of the case diary, it appears that the victim girl in their statement recorded under section 183 of BNSS have not implicated the petitioner in any manner as alleged in the FIR, in view of the aforesaid facts, also and also considering the period of detention of the petitioner within bracket 35 days, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation of Kokrajhar PS case number 164/2025. So accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Ilaka magistrate with following conditions. Number 1, number 2, you cooperate in investigation. This bail application is accordingly disposed of. 18. Related case is then
Same affairs. Otherwise, the 482, clear is bill for the.
heard
lady
Mr.
law.
S.K. Poddar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Srimati Birkhang Sri Doimari, who is apprehending her arrest in
the
connection.
It's wrongly mentioned Birkhangri. I have given the alias name, Lordship.
Birkhang Sri alias Birkhangri Doimari, who is apprehending her arrest in connection with Kokrajhar PS case number 164/2025 under section 143/64 1 of BNS, read with section 3/4/5 of the Immoral Traffic within bracket Prevention Act 1956. List of accusations same as the earlier case. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He submits that the petitioner is working as what?
Manager, senior
Working.
employee.
Is working as
For the-
manager in the aforementioned aforestated saloon and
Relax unisex. Salon.
and is not involved in the offense alleged in the case. Stop. She, however, submits that no, learned counsel for the petitioner, however, submits that as the police is searching for the petitioner, she is apprehending her arrest in the aforesaid case. Hence, she has approached this court seeking anticipatory bail. It is further submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. Stop. Submission of additional PP from the earlier case. Reasoning same. In view of above, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the investigating officer of Kokrajhar PS case number 164/2025 within a period of 7 days from the date of this order and cooperate in investigation. If she does so within the stipulated period of time, in the event of her arrest in connection with the above mentioned case, she shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2. This anticipatory bail application is accordingly disposed of. Send back the case study.
Deeply obliged.
Item 12.
Yes.
Can I completed 20 days of custody, Lordship? Your Lordship.
How many
before-
days?
Lordship, since 2025, Lordship. We are often involved, our Lordship. 3082, that is bailable, Lordship. 351. That is also bailable, and 35 is common intention, and along with Lordship, 67 and 60D of IPX. Those are 5 years punishment, Lordship. And 3 years and 5 years respectively. Now, Lordship, before I place the FIR, Lordship, certain facts which are involved in this case are such, Lordship. The petitioner and the alleged victim, they are in love for many years. And
Many years.
they known to each other for many years. And they are in a very intimate relations since long, lordship. And in fact, lordship, it is admitted fact that the girl, for the purpose of, because they are almost in the same age, 26 around, both are in the same age. So for the sake of his establishment, lordship, to conduct a business, she has also deposited some money. That is also true, lordship. And he was in a process of starting that money, but it's in between, lordship, certain disagreements happened between them, which led to the cancellation of their marriage, lordship. And consequent to that, lordship, this instant affair has been lost, lordship. So now may I place that page 11, that is the affair, lordship.
What is the gist of affair? Instead of reading
That is the
vulgar videos, obscene videos were posted.
was strongly instructed by my client that no such video, lordship, never ever as taken by, and even in so far my instruction, believing on my instruction, that no video can be available. And lordship, the forwarding report, that is page 13, straight with even prosecution also, I'm placing that page 13, lordship, production of accused, arrested accused person, namely so and so, with a prayer to remand him in judicial custody. Even the cyber crime department also did not feel that he should be taken into police custody, lordship. They straightway prayed for placing him under judicial custody. That is also one of the aspects to be considered here, lordship. So this was the case, and I have been strongly instructed that no videograph has ever been taken by the petitioner. That is absolutely a projected story because of the refusal of the marriage that I have also detailed in my para yes, para 2 of my application. That is my case, lordship.
Yes, Mr. Sharma.
Lordship will kindly come to paragraph number 2 of their bail application, page number 3.
Era?
Para 2.
Yes, it is written.
Yes.
Lordship will kindly bear with me, okay? The petitioner was arrested on 20/07/25 and has been in custody since then. The allegation against the petitioners are absolutely false, fabricated, motivated by personal grudge. The complainant, who is older in age than the petitioner, has developed acquaintance with him over Facebook in January 2025. Just to show that point.
Oh, that does not tally with your submission. I asked,
The things will definitely tell you with my submission but the main allegation.
I
that
asked
have
how
video-
long? You said for long,
Long.
but it is,
Started for long.
but you have mentioned it wrongly then. You have mentioned January 25. Which one is correct?
It is on oath, lordship. This para 2, lordship.
Because if you make wrong submissions, then you will lose credibility.
But that.
Do you need the custodial interrogation further?
So, I may be permitted to place the facts. Lordship. After
Yes.
that, I can answer this.
Yes.
Page 13, Lordship, forwarding. It is not a simple case of making the videos viral, Lordship. What has transpired after, then Lordship will kindly take that. Page 13, Lordship, this is the forwarding.
Yes.
Brief of the case, just to point out, Lordship, I will skip the first 4 or 5 lines, Lordship. She came to contact with one person, namely Soyan Roy, Lordship has found it, of Lala Hailakandi through social media platform Facebook, and they came into relationship.
What is the name of the petitioner?
Soyan Roy.
Soyan Roy.
Yes. They came to relationship since January 25. On 9/2/25, the informants, the victim woman, Lordship, along with her boyfriend, went to Silchar, and both of them stayed in a hotel named Kunjalata Lodge near so and so. After a few days, the informant and her boyfriend Swain received some messages from an unknown Facebook account, namely Aluddin Ahmed. Lordship will kindly take note of this, Lordship. And also the same person, Aluddin Ahmed, sent her friend request in Instagram. The unknown person stated that he had a vulgar video of the informant and her boyfriend in a compromising situation. He sent the video clip to them as a proof. The unknown person threatened them that he will viral the video if they do not pay an amount of 3 lakhs. The unknown miscreant also threatened them not to report the incident to police. On 18 February 25, the informant took a gold loan from Muthoot Finance Karimganj branch of an amount of 1.25 lakhs and transferred the said amount to the account of her boyfriend, that is so that he can pay the amount, pay the money to the person who was demanding money. On 19 to 25, her boyfriend, along with one of his friends, namely Suraj, went to a location near so given by the extortionist to pay the money. After the first payment, another person, namely Zubair Ahmed, started demanding money of an amount of 2 lakhs through Facebook. One more person came into the picture. Again, on 24th March 2025, she took a gold loan of an amount of so from Muthoot Finance in the name of her brother. Next page, Lordship, on 24th March 25, her brother Shiv Shankar paid an amount of 1 lakhs to her boyfriend Sayan, and the rest of 96,450 was paid to Sayan through GPay on 25 March, so that her boyfriend can pay the money to the unknown culprits who was demanding money. Again, in the month of April, her boyfriend Sayan informed the informant that the blackmailers had contacted him and demanding money of an amount of 90,000. The blackmailers demands for money every time from a new Facebook account. After contacting the informant, the miscreants immediately deactivates the fake Facebook accounts. So far, the informant had paid total of 3,21,450 rupees. The informant has mortgaged her gold jewelry for taking the gold loans. The informant has transferred the money to Science Roy's bank account number so and so. The link of the Facebook account and the Instagram account from where the culprits have contacted the informant are so and so. So this is the facts of the case. Thereafter, Lordship will kindly see grounds of arrest. Point number 6. In the course of investigation, the details of URL of the alleged Instagram accounts have been collected from the Meta platform, which revealed that the mobile number used in the said fake account is of Sayan.
Oh my God. So now,
Now, Lordship, her 180 has been recorded, Lordship. She did not know what was happening, Lordship. Thereafter, Lordship, she stated once she stated to her boyfriend that I have lost the criminal case, then suddenly the threats stopped. No extortion was made. Then she suspected Lordship, and then it was reported to the police, and then her 180 was recorded.
so there are implicating materials, but now do you require?
So that requirement will be based on the money trail is yet to be investigated. The money trail, Lordship, that the money was paid, Lordship, that is still under investigation. Today is, Lordship, 17 days to my calculation, Lordship. If I'm not
Yes, there are.
Whether they have proof of that. To substantiate that allegation, that is the gist, that is the absolute.
183 statement.
Yes.
But the statement, Lordship, that is because I have mentioned that it is a projected story because of the refusal of the marriage at this stage. All has been brought. This all transaction is submitted, Lordship. All transaction made through his account. And that was paid in a different for a different purpose, for establishing business, Lordship, to start their career. Thereafter some disagreement. And now, Lordship, whether prosecution has collected any kind of video that is to be viral by me, any sort of things that they have, Lordship, apart from the statement.
No, video was not made viral. Threat was there that unless you pay.
Now that is the basic. That is why I'm under detention, Lordship.
Heard Miss T. Som, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner namely Shri Sayan Roy, who has been detained behind the bars under section behind the bars in connection with CID Cyber PS case number 5/25 under section 308 slash within bracket 2 slash 351 within bracket 4 slash 3 within bracket 5 of BNS read with section 67A slash 66D of the IT Act. The gist of accusation in this case is that on 4/4/2024-25, the victim girl had lodged an FIR before the officer in charge of CID Cyber PS case, CID Cyber Police Station, inter alia, alleging that the informant came in contact with the petitioner through social media platform, that is Facebook, in the month of January 2025. And thereafter, they developed a romantic relationship. It is alleged in the FIR. After a few days, the petitioner told the informant that he had received some messages from unknown Facebook account of one Alauddin Ahmed, where he has threatened to upload a vulgar and an obscene video of the petitioner and the informant in compromising position in the social media. And asks for payment of an amount of 3 lakhs for stop. It is alleged in the FIR that accordingly the informant took loan from Muthoot Finance Company and paid rupees 1.2 lakhs to the petitioner for paying the same to the blackmailer. It is alleged in the FIR that on several occasions the petitioner told the informant regarding the threat by different persons of uploading the obscene video of theirs, obscene video of the informant and the petitioner, and demanding money in lieu of that. So, in the FIR, she has not made allegation against the petitioner. She has made,
At point of time, Lordship,
she was not
she
knowing.
was not-
No, okay. Stop. Learned counsel for the petitioner has submitted that the petitioner is innocent and no accusation has been made against him in the FIR. She submits that the petitioner and the informant were in a romantic relationship since long, and when there and some dispute arose between them, and therefore she lost the FIR. Learned counsel for the petitioner has also submitted that the petitioner is admitting, petitioner has admitted the fact of receiving money from the informant, but that was only for business purpose. She submits that no obscene video has been uploaded in any Facebook account. She also submits that the petitioner is ready to cooperate in the investigation. So, on the other hand, learned additional public prosecutor has produced the case diary of CIDPS case, CID Cyber PS case number 5/2025 and has vehemently opposed the grant of bail to the petitioner at this stage. He submits that during investigation, it was found that the Facebook accounts in which the obscene photographs of the informant and petitioner were uploaded, were fake account created from the mobile phone of the present petitioner only. He submits that there are sufficient evidence material in the case diary to indicate that petitioner, in view of duping the informant, himself used to send messages in his phone through fake accounts and through unknown numbers. He submits, learned counsel for the learned additional public prosecutor submits that the investigation is still at early stage, and considering the incriminating materials available against the petitioner, he prays for dismissing the bail application. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary which was produced by learned additional public prosecutor. I have also perused the statement of the victim girl recorded under section 183 of BNSS stuff. It appears that at this stage of the investigation, there are incriminating materials in the case diary which indicating to the complicity of the petitioner in the offense alleged in the FIR. Stop. Considering the stage of the investigation as well as incriminating material present against the petitioner in the case diary, this court is reluctant to grant bail to the petitioner at this stage. The prayer for bail is therefore rejected. Send back the case diary.
One more. He's a student of BA semester.
Learned counsel for the petitioner has submitted that as the petitioner is a student of BA course, BA which year?
Second semester.
BA second semester, and as he is ready to cooperate in the investigation, he may be allowed to go on bail.
Finding item 2.
Do you require his custodial interrogation?
I don't know whether they will cooperate or not. It is a question of 1 crore some amount of the.
No, suppose if he cooperates in the investigation. Interrogation and custodial interrogation, there are the. So he is agreeing to it. You have received no notice. You received notice under 91 only. But you are saying that you may
No,
require.
Because investigation is going on. At what point of time, we have already given.
So there is a possibility of his getting detained. No, you have to be honest to the court. What the IO has stated to you. Is he going to arrest him?
Still conducting the investigation because the larger conspiracy is involved.
No.
Paper
On
advertisement.
the
has been-
last occasion, this court directed, there is a request made by this court to you to obtain instructions from the investigating officers, whether
Reply to their petition.
what he has.
Today it has been filed. I have served him. Maybe it is not on the record.
What he has stated.
I
No, you can tell me what he has stated. Just don't read entire.
It
What is the
just-
gist? Whether he will require custody.
Dilip Chandra Bora, Senior Public Relation Officer, Sri Hardhan Day, and since retired, and Sri Hitesh Deka, and some unknown person, and one Kabir Das Purkastar. He is a senior cashier. In paragraph number 3, FIR, this FIR is filed for the publication of advertisement of the notice inviting tender were issued deliberately and indiscriminately to a lesser known regional and vernacular newspaper published far from jurisdiction of the work to be executed, non-approved newspaper and newspaper not in circulation during the relevant period created a false office record of giving advertisement of NIT, and in some cases they fraudulently raised and made a payment more than once against same advertisement. It is further alleged that an amount of rupees 4.00 crore was normally sufficient for giving a advertisement of NIT by construction department of NFR, but more than 10 times of the normal requirement was spent by the accused public servant by adopting an unfair means as stated above. The FIR further alleged that NF Railway had made an expenditure of rupees 157.54 crores during the period 2014 to 2018 against 5,842 bids raised by near about 320 newspaper for publication of the advertisement of notice inviting tender issued by NFR. It is also alleged that in the FIR that in some cases advertisement were issued in enormous space and fonts than the standard space and font size by floating and norms of the railway board. Thereby we have given the parawise reply. Again, there is some middleman is also involved. His name is Bhagwan Dasya.
In many cases already granted 3 years bail.
No, whether any accusation against
Because there is a transfer
against
of money.
AK Sani
Yes,
Abdul
transfer. That the investigation is revealed that.
at two, we'll continue. We'll continue.
Going to forward, item number 1.
For reasons mentioned in the order, the prayer for anticipatory bail of the petitioner is rejected. The interim anticipatory bail granted to the petitioner is hereby vacated.
very much.
Item 3.
From the CD also, and we have given the reply also, that on 2 occasions, he has transferred an amount to the accused number 1, Dilip Chandra Bora, who was
When?
accused number 1 in this case, and the amount has been transferred. And it has been given in my paragraph number 12 on 2 occasions.
You have a copy, photocopy. Which para?
Page number 31, para 12, your lords. While rebutting their paragraph number 8, 10, 11, 12, we have made an clarification. It is submitted that the custodial interrogation is the part of the investigation and discretion of the investigation officer to be exercised in the interest of effective investigation of the instant case. And in the present case, huge amount of money is involved, and the applicant has received an amount of rupees 1 crore 11 lakh and so from NF Railway in connection with the fake advertisement bill. And out of this, he had made a payment of rupees 49,000 on 8/3/16 and another payment of 49,000 on 9/3/16 from account number so of MSEQ Kwame Delhi to one FIR named accused Dilip Chandra Bora to his account number so. In this large conspiracy of the accused public servant of NFR, and if protective umbrella of the anticipatory bail is given to the accused applicant, then he may not cooperate with the investigation, resultantly inimical to the interest of effective investigation. So there is a transfer of amount, and moreover, this newspaper is not the recognized one for the purpose of the advertisement.
Yes, what you have to say.
First of all, my lord, the allegation was against 6% and an employee.
That
I have
is
not been
given in
named
the first
accused.
page, your
And
lord.
the main accused, my lord, has already been granted bail. 3 years.
Where is the bail order?
My lord, your lordship, kindly see NHS 6, page 24. And
If he has been granted bail, that is
There-
wrong back.
they are mainly objecting only because if anticipatory bail is granted, I may not cooperate. That is the only ground.
This is the order of 2019, your lordship.
Yes, what else?
And regarding the transfer of money of 98,000 or 49,000, something like that, my lord. Those are the excess amount, my lord, which is also I have refund back, my lord.
But it has gone to the account of accused number 1.
Yes, in his
First
account, my lord.
account.
And I'm ready to cooperate, my lord. I will explain what happened. And now, my lord, they have issued the notice asking me to furnish certain document. Your lordship, kindly say annexure 2, page 22.
Yes.
Well, normally we don't keep the copy for after 5 years, we don't keep the copy. And this newspaper, my lord, was abolished in the year 2020, my lord, no longer exists at present. So I have already written a reply. In my reply, my lord, I have clearly stated that those documents are not available with me.
Okay. Heard, Mr. I. Rafiq, learned counsel for the petitioner. Also heard Ms. M. Kumari.
Still investigation is going on.
Okay.
CD is here, up to date CD is here.
Learned standing counsel for the CBI. This application under section 482 of BNSS has been filed by the petitioner. Has been filed by the petitioner, namely A.K. Ahsani, alias Abdul Khalik Ahsani, who is apprehending his arrest in connection with CBI/ACB Guwahati PS Guwahati case number RC 0172019A0006 under section 120B/409/420/468/471 read with section 13 within bracket 2/13 within bracket 1 / within bracket C / within bracket D of Prevention of Corruption Act 1988. Where is the FIR?
FIR is at page 14. Page 11.
The gist of inquisition in this case, the gist of accusation in this case is that on June 7, 2019, one P. Thangzalian, SP and head of the branch CBI ACP had lodged an FIR naming therein 5 accused persons, 6 accused persons, inter alia, alleging that the accused persons named in the FIR were suspected to have falsely created record of giving NIT advertisement in newspapers which are not in circulation, and thereafter have passed fraudulent bills for same advertisement on more than one occasions. Stop. You are named in the FIR.
No,
Learned counsel for the petitioner has submitted that the petitioner has not been named in the FIR. However, he has received a notice under section 91 of the Code of Criminal Procedure 1973 on 28/4/2025 from the investigating officer of the aforesaid case, whereby he was directed to produce certain documents before the investigating officer. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the investigation. However, some of the documents mentioned in the notice under section 91 CRPC are not available with him. Hence, he may not be able to produce the same before the investigating officer. Therefore, he apprehends that if he appears before the investigating officer, he may be arrested. Learned counsel for the petitioner also submits that in the meanwhile, the accused number 1 named in the FIR, namely Shri Dilip Chandra Bora, has already been granted anticipatory bail by this court on 29/8/2019. And as such, considering the fact that the petitioner is ready to cooperate in the investigation, he may be granted the protection of anticipatory bail. On the other hand, learned Special Public Prosecutor, CBI, Special Public Prosecutor, Standing Counsel, learned Standing Counsel, CBI, Ms. M. Kumari, has opposed the grant of anticipatory bail to the petitioner at this stage and has submitted that the investigation is going on. And as the case involved, as the offense involved in this case involves involves corruption as regards huge quantity of money, there may be necessity of custodial interrogation of the petitioner. She also submits that the investigation till date has revealed that the petitioner has received an amount of rupees 1,11,75,958 from NF Railway in connection with fake advertisement bills, out of which it appears that he had made payment of rupees 49,000 each on 2 occasions to the account of accused number 1. Stop. He submits that as the involvement of petitioner in the alleged offence is apparent, the anticipatory bail may not be granted to him at this stage. I have considered the submissions made by learned counsel for both sides. It appears that the FIR has been lodged in this case in connection with offense alleged to have been committed in the year 2016 by the present when the offence was
15 to 2017-18, page
2000.
number 16 of their
2014 in the financial year 2014-15 to 17-18.
It is reflected in page
And
number 16 of their application.
the acquisition of payment of money by the present petitioner to accused number 1 is also relates to accused number 1 also relates to the year 2016, which is about, and 10 years have lapsed since then. It also appears that the accused number 1, Shri Dilip Chandra Bora, to whom it has been alleged that the petitioner has made payment to get undue favors, has already been granted bail, has already been granted anticipatory bail. Stop. Under such circumstances, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of the aforesaid case. For aforesaid reasons, the notice date has lapsed, 91 notice.
Yes.
for aforesaid reasons, a petitioner is hereby directed to appear before the investigating officer of aforesaid investigating officer of CBI/ACB case number RC 01-72019A 0006 within 7 days from the date of this order and cooperate in the investigation. Stop if he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be granted bail by the arresting authority, bail of rupees 30,000 with one surety of like amount by the arresting authority with following conditions. Number one, number two. This anticipatory bail application is accordingly disposed of.
7 days from the date of receipt of the certificate copies. 7 days from the
No.
date.
10 days from the date of the order. 10 days from the date of the order.
I just have some supplementary list. Maybe.
Yes.
Kindly see the last order.
Whether current status has come. What is your name? Dilwar?
Dalil Sheikh Profit.
Yes. Now what is the submission?
Yes, there is a negligence, also there is a delay on the part of the court as well as prosecution Lordship to conclude the trial within reasonable time Lordship. Here is a petitioner is behind the bar last 3 years, 8 months Lordship. So his
What is-
fundamental right has highlighted Lordship. His right to speedy trial Lordship. And more so Lordship, at the time of his arrest, he was not Lordship served the notice under section 48 and 47, 48 Lordship. Background I was taken in this petition.
Section 47, 48 was not in existence.
No Lordship, 50 and 58 Lordship. 50 and 50.
Okay. Status, the evidence has started.
No Lordship, in this case, I have also last occasion pointed out the earlier rejection order, that is page 35 Lordship. As per direction of that order, we have filed a petition for split of the trial Lordship against me, against the other accused person Lordship. Last occasion, that is why the order has been passed, calling for the report about my petition Lordship. Page 35 is the order Lordship.
Now charges were framed or not.
No, Lordship, all the witnesses has been examined. All the witnesses has already been examined.
Okay, then
Then Lordship, because due to one accused, he jumped that over the trial. Due to his absence, the case could not proceed further. That is why the earlier engaged counsel also filed a petition for spirit of the trial. Again, we also filed the petition for spirit of the trial. But till date, our petition has yet not been disposed of.
The status does not shows.
No, Lordship, I have seen, it is still pending, Lordship.
Yes, yes.
I would like to go to the report, also. It did not go to regarding the stage of trial. Also.
Stage it. Evidence is over. Evidence is over.
Yes.
In respect of the petitioner.
Lordship,
It was, how many witnesses have been examined?
7 cited listed witnesses. They are already at the-
Seven have been examined.
Yes. Lordship, the last witness was examined, I have reported on 7/7/2023. It is the duty of the court to take the Lordship trial day-to-day basis, Lordship, as per the decision of the Swatandra Singh until. And the right to speedy trial is a Lordship fundamental right under Article 21. So Lordship, there is a violation. On that ground, Lordship, he is entitled to. And the other aspect, Lordship, 50 and 50A, that is also not communicated, Lordship. As per the decision of Lordship, Purvir Prakasta and Bihan Kumar.
Heard. Yes, you have anything? Let him appear. We will direct split. For he is behind the bars for 3 years. 3 years,
8 months.
8 months. Heard Leonard, heard Mr. AZ.
Kindly just take care of the apprehension that he may abscond, because
Yes, we will.
courts may put appropriate condition.
From where you be,
West Bengal,
Yes,
same as the other cohesive.
what is the assurance that you will come?
Lordship, still the condition to ensure his safety.
Like
Like,
you suggest.
Lordship,
Security of a government servant.
maybe, Lordship.
Heard Mr. AZ Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Dalim Sheikh, who has been detained behind the bars since 6/12/2021, within bracket for last more than 3 years, 8 months, bracket close, in connection with NDPS case number 95/2022, presently pending in the Court of Learned Additional Session Judge number 3, Kamrup Metro at Guwahati. The gist of accusation in this case is that on Five 12/2021,
Visit Gogoi, yes, sir.
Abhijit Gogoi had lodged an FIR before the officer in charge of Gorsuk Police Station, inter alia, alleging that an information was received through reliable sources regarding a vehicle carrying huge quantity of prohibited drugs, stop. Accordingly, a police team was constituted and the Naka checking was organized at Raju parking situated at Boragaon, and vehicle bearing registration number WB652150 was intercepted. During search of the said vehicle, two persons, including the present petitioner, were apprehended therefrom. During the search of the said vehicle, what was found?
2.56 kg of heroin.
2.56 kg of suspected heroin was recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner has been facing trial in the aforesaid case before the court of Learned Additional Session Judge number 3, and all the prosecution witnesses have already been examined and the prosecution evidence have been closed by the trial court by order dated 17/7/2023. He further submits that though the NDPS case number 95/2022 was fixed for examination of the accused persons under section 313 of the Code of Criminal Procedure. However, due to absence of the co-accused, namely Dilwar, alias Muhammad Dilwar, the trial could not be proceeded further. It is also submitted by learned counsel. Dilwar was granted bail.
Granted interim bail, certain conditions, lordship, due to some medical reason. How
Learned counsel for the petitioner has also submitted that on 17/7/2023, the co-accused Dilwar alias Muhammad Dilwar was granted interim bail with certain conditions on medical conditions for performing the last rites of his mother, deceased mother. Stop. However, the co-accused Dilwar jumped bail and thereafter never appeared before the trial court, and the trial is not progressing since then. He further submits that the petitioner had also filed application for splitting up of his case from that of the absconding accused on 2 occasions. However, the trial court has not yet decided the application filed by the present petitioner. In spite of an observation by this court that the petitioner may file such an application before the trial court. Stop. Learned counsel for the petitioner has submitted that the prolonged incarceration of the petitioner for more than 3 years and 8 months have resulted in infringement of his fundamental rights guaranteed under Article 21 of the Constitution of India. He therefore submits that on the ground of prolonged incarceration and consequent violation of his fundamental rights under Article 21 of the Constitution of India, he may be allowed to go on bail. Yes, Mr. Sharma, anything? Learned additional public prosecutor, while pointing out that the contraband seized in this case is of commercial quantity and therefore the embargo of section 37 of the NDPS Act would be applicable, has submitted that in case this court grants bail, very strict conditions may be imposed as the petitioner hails from West Bengal and as the co-accused has already jumped bail. Stop. I have considered the submissions made by learned counsel for both sides. The apex court in several of its judgments have observed that prolonged incarceration overrides the embargo of the section 37 of the NDPS Act. Stop. In a case where the court comes to a finding that the incarceration of a person is long enough so as to infringe the fundamental rights guaranteed to him under Article 21 of the Constitution of India, it would override the embargo of section 37 of the NDPS Act 1985. Stop. In the instant case also, though all the witnesses have been examined way back in the year 2023, and since 21/7/2023, this case is pending for examination of accused under section 313 CRPC. This court is of considered opinion that the right of the petitioner to get expeditious trial has been violated in this case. The prolonged incarceration of the petitioner has resulted in violation of his fundamental rights guaranteed to him under Article 21 of the Constitution of India, and therefore he is entitled to get bail. For aforesaid reasons, the petitioner is hereby directed to be released on bail of rupees 2 lakhs with 2 sureties of like amount, one of whom should be resident of the state of Assam with following conditions. There are trial conditions. Munmunor Poral value. This bail application is accordingly disposed of.
But 2 lakhs, that will look two sureties, maybe okay, 1 lakh lordship. With quantity of.
Quantity is too much.
Two.
Lordship may have a look at the order dated 5/8/25, the last order.
No, what is your submission?
My lord, I have filed the written submission, my lord, and a copy has been given to the prosecution, my lord, on 6th itself, my lord. Today, my lord, the PP is supposed to reply on that.
No, you can tell me the gist of your submission.
My gist of submission is that, my lord, the petitioner was initially arrested in a case, my lord, and he was behind the bar. Subsequently, my lord, a charge sheet was laid in another case, my lord, where summons were issued by the court. When the summons, the police went to serve the summons to his house, my lord, it has been informed that he has been arrested in some other cases, my lord. So accordingly, the special judge, my lord, issued production warrant, my lord. And accordingly, the petitioner was produced before the court, my lord, and he was remanded to the judicial custody, my lord. So now the question arises, my lord, whether grounds of arrest is required to be served upon the accused
It
petitioner.
was a charge sheeted case.
It's a charge sheeted case, charge sheeted case. And for the time being, let 47 not be there, 48, whether my family member should be informed or not. That was the case, my lord. And the last occasion I relied upon a judgment, my lord, Dhanraj Aswani, my lord, that was reported in 2410 SCC, my lord, where it says, my lord, whether the order of remand by the court be equated to with an act of arrest, my lord. The court held that for the purpose of remand, as in the case of arrest, is to collect evidence during investigation, and thus amounts to one and the same thing. So far, my lord, 47 at present, I'm not arguing, but so far 48 is concerned, my lord. As I am behind the bar in another case, I was produced before the court, my lord, on a production warrant, my lord, and I was remanded, my lord, custody warrant is issued. Whether my family members should know or not. Therefore, I can take recourse to the law by taking assistance of an advocate. That was the case, my lord. And lordship has directed us to file a written submission with a copy to the prosecution in advance, my lord. On 6th, we have served a copy upon the PPP.
Yes, please, sir.
My lord, in this aspect, my lord, the statute is not specific, my lord. As per section 48. For my understanding, I am again try to read the section 48 of the NSS. In this case, my lord, production warrant was issued on 3/5, ultimately on 11/4. 11/4, he was taken into custody and custody warrant is issued. And subsequently, our record shows that 3/5/25, he has been represented by the advocate, my lord. That's section 48 of the BNSS, my lord. Obligation of persons making arrests to inform about arrests, etc., to the relative of offense. One, every police officer or other person making any arrest under the Sanhita, under this Sanhita, shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other persons, or as may be disclosed or nominated. Now, my lord, yes, he was in custody, he was in jail in connection with another case, my lord. Talmara, same PS, 4/25. So subsequently, my lord, US production, after the production, my lord, he was remanded. But fact is that, my lord, regarding the 47, 48, my lord, intention of the legislature is there, but as per my understanding, family members or friend has to be informed immediately so that the person accused who is in custody, for him immediately and counsel advocate can be arranged by the family member as he is in custody.
Yes.
So now, in this case, an advocate is there, my lord, for the earlier case. Obviously, my lord, in the earlier case. So when you are produced before the court, so that advocate may know regarding that case also, my lord. Only regarding the authority. Authority has to be given for conducting the case of the second case, my lord, new case. So in that aspect, my lord, whether, my lord, that person has been prejudiced, and now, as per the custody decision, my lord, warrant, maybe a production warrant, my lord, if he has been explained the ground, it is not warrant is, if the warrant is read over, then it is not necessary. If 47 is not necessary, then why 48 is necessary, my lord? If 47 at that point of time is not necessary, my lord, as per the, my lord, Article 22, my lord, will come regarding the 47, my lord. And 48 in the Bihan Kumar judgment also, regarding the 48 last few lines of the, my lord, Honorable Justice Kotesh Singh, my lord, in the Bihan Kumar judgment also.
Yes.
There also, my lord, it has been stated regarding the, my lord, just I am reading the last paragraph
Yes.
out of Bihan Kumar. The purpose of inserting section 50A of the CRPC, making it obligatory on the person making arrest to inform about the arrest to the friend, relative, or persons nominated by the arrested persons, is to ensure that they would able to take immediate and prompt action to secure the release of the arrested person as permissible under the law. So that is the, my lord, motive of the, my lord, intention of the Honorable Supreme Court also, my lord, this. So immediately the friend's relative has to be informed so that he can, my lord, advocate can be arranged and he will get the reasonable opportunity of hearing, my lord. So here also, my lord, making arrest to inform. Now, Learned has that place that judgment, my lord, regarding remand and arrest similar. But that case judgment, that judgment also stated that, my lord, in case of if the warrant is read over, 47 is not necessary. When 47 is not necessary, and it is not like that advocate is not there for the case already which he is in under custody. In that case, an advocate is there. So that advocate only authority of wakalatnama is necessary for the new case. So he will get the reasonable opportunity is there, Malak. So how he will prejudice, Malak?
So if counsel is engaged,
Now, in this aspect, Malak, I have searched, Malak. I have not found any such judgment, Malak, regarding this aspect, Malak. That mandatory, it should be given, not specific, Malak. I have not yet found, maybe, but I have not found. And statute is also, Malak, 48 also stated that any police person making arrest, Malak. So when Malak statute is Malak, not specific, and no Supreme Court authority till that I have found, Malak. So in that aspect, Malak, my submission is that when 47 is not necessary.
48 says police person or other person.
or that person making arrest.
making arrest.
So, his custody arrest, every police officer or a person making any arrest under this Sanhita. So, in this case, Tasit already issued, he was shown as absconder. Someone issued, warrant issued, and when someone has come that he is already in jail in connection with other case, subsequently production was US product produced.
How much contraband is involved?
My lord, here, my lord, 75 numbers of cough syrup. 75 bottles of cough
Bottles of
syrup
cough syrup.
and 13920 capsules. And it was recovered from other persons.
Okay.
And
Mozambique-
my lord, my friend is saying, my lord, he is relying that Keshi Reddy's case, my lord, where it says that, my lord, if a warrant is read over. In the instant case, my lord, it is a production warrant. And the production warrant, my lord, it is in form 37. Production warrant is, my lord, given to the officer in charge of a jail. You produce that person. Well, my friend has not gone through, I think it's a form number 37. It cannot be equated to that warrant, my lord.
Arrest warrant.
Yes, my lord. It is a direction given to the jail authority that you produce the person in this case on so and so date. It is a direction given to the jail authorities. That is not a warrant. It cannot be equated with that warrant, arrest of warrant. So I am on the basic, my lord.
Arrest warrant is also addressed to the executing of police officer.
In Keshi Reddy's case, my lord, the warrant was, my lord, substantially very grounds were given, my lord.
Okay, you have raised a legal
My-
point.
And my lord, I am on 22(1), my lord, where it says, my lord, no person who is arrested shall be detained in custody without being informed as soon as possible on the grounds of such arrest, nor shall be denied the rights of to consult or to defend by a legal practice.
Okay.
That aspect will come under section 47. This 48 will speak about the friends and relatives. Senior has stated that I am not relying upon the 47. Only
For time being
for
keeping
time-
up, for time being keeping apart.
So I am stating about 48, my lord.
Okay, heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let this case be listed for delivery of orders on 18th August.
I have trademarked the orders and all this in the
Okay.
scan copy.
I am obliged, madam, deeply obliged.
On 18th.
18th August.
Here, was unable to contact the police station, so if kindly fix it on Monday also, I will take the inspection regarding service of.
You have corrected the cause title.
Yes.
Okay, heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that, who prays for some more time to get information regarding the fate of notice issued to the respondent number 2. The prayer is allowed. Let this matter be listed on
So that may be given.
12th,
Otherwise-
12th August,
otherwise second witness has already been.
Tuesday. 12th of-
44. Make it yours.
Yes.
The allegation is under section 22C of the NDPS Act. The allegation in a nutshell is that the complainant along with 4 others, they were all personnel of Guwahati GRPS. they had gone to the Guwahati railway station at about 5 a.m. on 20th of March 2024 to perform platform checking duty. My lord, at 7:35 a.m., my lord, a Shilchar Coimbatore Express, my lord, it arrives at the platform number 4, and the complainant, along with the rating members, they start checking the bags and luggages of the passengers in a particular coach, my lord, coach number B4, as per the complaint, my lord. Now, my lord, during this checking, my lord, they found a particular passenger, my lord, that is the present petitioner, seated at seat number 63. They found him to be suspicious, so they brought him down from the train on that suspicion. And after that, my lord, allegedly 10,000 Yaba tablets were recovered from the bag of the petitioner, my lord. My lord, that is the sum and substance of the allegation as per the prosecution, my lord. Now, my lord, I will beseech my lord to kindly go through the memo of arrest, my lord. My lord, that is appearing at page 16 of my application. My lord, there is no signature of any witness, my lord. My lord, it is blank. Now, my lord is very well aware, my lord, that the failure of the arresting officer to obtain the signature of an independent witness on the memo of arrest, it is not a mere procedural lapse, my lord, but it is a material irregularity, my lord, which goes to the root of the arrest and casts a serious doubt upon the genuineness of the prosecution story, my lord. Now, my lord, secondly, my lord, I will beseech my lord to go to the Caesar list, my lord. My lord, according to the prosecution, the entire Caesar has been made on a platform, my lord. But surprisingly, my lord, the Caesar list, my lord, I have not annexed it to the application, my lord, because of paucity of time, the copy was not available to me. I will beseech my lord to go through the same in the case diary. My lord, in the Caesar list, my lord, there is no reflection or there is not a whisper about a platform ticket or a railway reservation ticket pertaining to this particular petitioner, my lord. My lord, in this case, my lord, charges have been framed, my lord. They were framed on 11th of September 2024, my lord. My lord, 11 months have elapsed, my lord. There are 8 witnesses, not a single one has been examined till date, my lord. My lord, I am in custody for 1 year, 5 months.
1 year?
My lord, 1 year, 5 months as on date, my lord. My lord, charge sheet was submitted on 30th of July 2024.
What is your main contention?
My lord, my main contention is that, my lord, there is no independent witness in the memo for us, but surprisingly, they have an independent witness who was there during the time of the Caesar. And my lord, secondly, my lord, in the Caesar list, there is, besides the contraband and a mobile phone and the backpack of the accused person, the present petitioner, my lord, there is no railway ticket. There is no railway platform ticket to substantiate that, yes, he was the person who was present at the platform, or it was his bag, or he was present inside the railway compartment, in the train's compartment, he was brought under. My lord, without a railway reservation ticket, possibly, my lord, a person cannot travel on a train, and neither can he be inside a platform.
Whether notice under 47 was given?
My lord, notice under 47, my lord, was 47 a notice reached? No, my lord. No. My lord, as per instructions, my lord, no notice was given under 47.
You find out. Because that would be, that may help you.
My lord, 47 notice. No, my lord. No, 47 notice is not there, my lord.
But you are not taking that plea.
My lord, because my lord, like I said, my lord,
because these pleas are not very strong.
My lord,
Oh,
my lord, 1 year, 5 months in custody, my lord, 47 notice has not been given. As per my learned junior's instruction, my lord, he is conducting the case before the learned trial court. My lord, he has told me that 47 notice was not served upon him.
You take that plea.
My lord, 1 year,
1
5
year,
months.
5 months is not long enough.
My lord, not that, my lord. My lord, 11 months have passed from the time of framing of charge. My lord, only 8 witnesses are there.
But
my lord,
1 year, 5 months is not long enough to
my lord, not a single witness has been examined, my lord. Not a single witness. And my lord, there is no independent witness in the arrest memo, my lord. My lord, kindly, my lord, page 16 once. My lord, no independent witness in the arrest memo, but they find an independent witness during the search and seizure.
No, those are on merits. You find out whether 47 and 48 notice has been given or not.
My lord, I'll grant me some time, my lord. I'll take further instruction from conducting advocate and return trial court, my lord.
Now, what is your prayer?
Lord, I'll pray for a short adjournment, my lord, for some time, my lord.
Okay. Heard. Mr. What is the name?
My name
J.
is
Bhattacharya.
Prajnaditya Roy, my lord.
R. Roy. learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned counsel for the petitioner has prayed for a short adjournment for taking some instructions from the petitioner as to whether there would be a requirement of filing an additional affidavit or bringing on record certain facts which are relevant to this case. And also seeks leave of this court that if necessary, he may be allowed to file an additional affidavit. The prayer is allowed. Let this case be listed when.
My lord, any date after the 25th of August, my lord? Or my lord, prior to 20th of August? my lord?
25th of August, episode. 27th
Great,
August.
great, great.
Hearing item 13.
Petitioner is an interim and he has appeared and the statement has been recorded.
Is there?
Zintu Borgohan. On this statement. Kumina Pachi, 11.
Heard Mr. S. Dekar.
Uh,
Also heard Mr. K. Parashar, learned. Heard Mr. S. Dekar, learned counsel for the petitioners. Also heard Mr. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioners has submitted that the petitioners, namely Jintu Borgohain and Sanjay Gogoi, were granted interim bail by this court on 11/6/2025. And in pursuant to the directions of this court, both of them have appeared before the investigating officer and have cooperated in the investigation. On the other hand, learned
Statements are not there.
anything to indicate that they have appeared.
So some that's why I'm saying 11/6 MP 14/6 and subsequently MP of 25/6. But this is not showing that appear. Regarding statement, no note of the IOC.
Earlier, Lordship, petitioner has approached the district and session judge Tinsukia, saying for anticipatory bail. In that bail application, the informant himself appeared before the Lana court below and submitted an application giving her NOC. That is at page 20.
No, you are already on interim bail.
Yes,
Question is whether to make it absolute.
already appeared, Lordship. I have the specific instruction.
No, but it is not indicated in the case there.
No.
What are the offense?
Otherwise, there are some doubts to the informant also, regarding the giving of the money. If they are cooperating, I actually don't have like to say anything, but regarding their
No, how to verify? You have to telephonically take instruction. Or we'll make it absolute on the basis of submission. Stop. Last line. On the other hand, learning additional public prosecutor has submitted that though the case diary is available, However, there is no endorsement of the investigating officer regarding the appearance of the petitioner before the investigating officer. Stop. In view of above, the additional public prosecutor is requested to take telephonic instructions regarding the appearance of the petitioner before the investigating officer, and let this court know about the same on the next date fix. Let this case be listed on 18th of August. The interim bail granted to the petitioners shall continue till next date. Retain the case diary till that date.
Important.
Wait, thank you, Lordship. Lordship, will you kindly take up order dated 24/7/2025, last order, madam. You Lordship may remember, madam, this is a case where red sandalwood was recovered.
What is the gist of order?
My lord, the issue here was that, my lord, red sandalwood was recovered from the possession of one person. That person suggested that this red sandalwood was given to him by me. Now, one of the points which we raised before this honorable court was that the case has been registered under sections 303 subsection 2, that is theft. Then 317 subsection 2, that is receipt of stolen property.
But there is no accusation
No
of
accusation to that effect that this was stolen. Now, other offences under the Assam Forest Regulations were under 24, 25, 40 and 49. 40 and 49 are not penal provisions, and 24 and 25 are basically, my lord, regarding offences which punish trespass or damage to reserve forest, my lord, or cutting or felling trees in a reserve forest. Now, as regards the offences under the Wildlife Protection Act, my lord, the case has been registered under section 17C, 17D, and section 51 of the Wildlife. Now, section 51 is the penal provision, and 17C and 17D, these are the main substantial provision wherein punishments have been given, wherein it has been prohibited. 17C prohibits the cultivation of specified plants. 17D prohibits dealing of specified plants. Now, both of these pertain to the articles which are there in Schedule 3, and Schedule 3, my lord, does not contain red sandalwood. Red sandalwood is in Schedule 4, my lord, and the corresponding offences pertaining to Schedule 4 is in Chapter 5A. The order
which
5B,
starts
my lord.
from which section?
My lord, chapter
5 is
5 is, my lord, I'll just, I have, my lord, marked it in the book, my lord. 5B, sorry, my lord, 5B starts from 49D. In the order, it has been written as 5A, it should be 5B.
5
B, chapter 5B.
B, capital B,
Chapter,
and ends with which section?
it starts, my lord, at 49B, and my lord, it ends at 49R.
49D to
49R.
49R. And there is no accusation under these sections.
Case diary was available, my lord.
No, but in the FIR, the case has not been registered under.
Case diary is available, my lord.
No, my query is, there
No,
is
it has
no
not been registered under chapter 5B.
49D or
It's not under 5B. It has been registered under 17C, 17D, which are Schedule 3 offences. So offences under which the case has been registered, none of these offences is attracted in the case, my lord. And Schedule, red sandalwood being a Schedule 4 article, my lord.
there is no accusation.
Accusation in that regard, assuming, my lord.
Schedule 4 relates to which chapter?
Chapter 5B,
5D,
5B.
5B.
That's 49A to 49R, my lord. So my respectful submission for your lordship is red sandalwood is only the international trade, illegal international trade, which is prohibited, which is an offense, my lord, which has not been invoked here. Otherwise, also, my lord, assuming that that may be an offense, if there is any material in the case I to suggest that these red sandalwood which was recovered from the possession of the co-accused
he is a subject matter of any international smuggling. Because red sandalwood otherwise is not indigenous to Assam. So
Suppose red sandalwood is found in somebody's possession, is it an offense?
mere possession is not an offense, but in terms of the wildlife act.
Unless it is a subject matter of smuggling,
Smuggling.
international smuggling. Yes, Mr. Gopal.
Well, I have appeared for the first time. I need some time because a report has been called for. Otherwise, controverting my learned friend, my lords, the Assam Forest Amendment of 2009, it doesn't speak to of any schedule, any offense. Earlier, red sandal was not within the schedule. By an amendment of 2022, a fourth schedule was created. And CITES, my lord, there's an authority of there's a convention of international trade and endangered species. Red sandal was brought within the ambit of the Wildlife Act. So in my case, well, I may need some time, my lord, in this case. I have to speak with the
His
authority.
main
also.
contention is that penal provision under which the case has been registered, facts does not correlate. Penal provisions is not in connection, is not attracted by on mere possession of sandalwood. That penal provision you have not included in this case.
It is a police case, madam. That is the difficulty.
So what is your prayer?
I require some time, my lords, because I found some communication in the case diary. The police authorities has asked us to clarify our stand. And also, my lord, that proposition, that wrong quoting of a section might not absolve the liability.
No, but there must be.
Yes, facts must correlate to the charge pressed. If the charge is pressed against a wrong set of facts, well, I'll request some time. I don't have I just took this petition copy, I don't have anything.
We are otherwise served, my lord. Perhaps there has been some miscommunication because we have made them a party also. Now, one thing, my lord, is my learned friend has submitted. Wrong quoting, this concept of wrong quoting of a provision, that is in regard of, my lord, whom somebody is seeking any beneficial relief, my lord. If in that regard, my lord, the wrong quoting of the provision will not debar him from getting the relief. But when a person
Deprived of liberty.
deprived of his life, liberty, my lord, in that case, his liberty can only be deprived of in respect of a particular accusation which is made against him. Here, the accusations which are made and the sections which have been invoked, they are not correlating, first of all. Secondly, my lord, the offense the allegation which has been made, that itself does not amount to an offense. Even otherwise, my lord, the item which has been found in the possession of another person. It is only the statement on the basis of the statement of that person that I am being dragged into the case, my lord. No evidence to suggest what is the source of this sandalwood, my lord, from where it was procured, how this arrived in the possession of the person, my lord, and whether this has got anything to do with any international smuggling.
You are not behind the bars now.
My lord, may I, because on the last occasion also, my lord, my learned friend had appeared from the prosecution, my lord. They sought time saying that we'll obtain some instructions.
No, but the
In the intervening period, they should have obtained. Now, my apprehension is, my lord, very late.
Well, that contention that is not for international, that doesn't hold any ground because sandalwood is now under the Wildlife Protection Act, my lords, which makes it a prohibited item. That
it is there in different
Schedule.
chapter and different schedule,
Yes.
which
But my lord-
under which you have not registered this case.
No, my lord, that is hit by this amendment of 2009. It doesn't speak of any schedule. It's irrespective of any schedule.
What it says?
It says every offense punishable under this act shall be cognizable and non-bailable within the meaning of so and so.
That only
Notwithstanding
speaks
any-
about.
Yes, madam. Notwithstanding anything contained in the code, madam, then it comes with two criterias that it is somehow at par with the NDPS section 37. Public prosecutor has to be given a chance, and my lord, if that the court has to also take into satisfaction, record satisfaction that he is not going to indulge in a second offense. So bare reading, I may be subject to correction, my lord. It doesn't confine itself to some definite schedule. It is irrespective of schedule.
No, that amendment what you are reading only says that the offenses would be non-cognizable
Yes.
and non-bailable.
Yes. Meaning thereby, my lord, if it could have been applied to only one schedule, it could have very well described that which schedule it will be applied to.
No, you are on wrong track. You go through the
Yes,
brief,
I have to go through.
go through the
I just
brief.
prima facie, yes,
Let him take some time.
I.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, as well as Mr. D. Gogoi, learned special public prosecutor.
Yes.
Special public prosecutor Wildlife, who seeks some time to go through the case diary is there.
Yes, that is there.
Go through the case diary before he makes his submissions. Let this case be listed when case diary is there. You suggested it.
Your lordship is an interim, my lord, then perhaps
18th.
otherwise my lord shorter leave.
18th.
18th. my lord,
Let
because
this case be listed on 18th.
My lord, in the.
The
in
case
this
diary
schedule,
may
we
be-
May also get arrested. my lord.
Case diary may be retained till
Yes, sir.
next year.
Always.
I'm deeply open.
For 82 application also, the petitioner is on interim and he has appeared before the CBI also. Earlier also his statement was recorded on 28/3/25, 11/4/25 and 26/6/25 and 27/6/25. Basically allegation is regarding giving
And
private to a public service.
What is the submission? Is he cooperating? Not.
Already is.
So the page number.
Only one submission I would like to make, because they are forcing me to give confessional statement.
It is.
And I have not given, that is what non-cooperation is. I have not given the confessional
No,
statement.
we are not.
And moreover, the
forcing-
prime
it is-
accused, he has been granted bail by this office.
Yes. Your lordship, we have filed an application for cancellation
is
of bail
different.
because he
That
is
is
not cooperating. The court has given an order to produce the laptop and iPhone, which is given by this Pavan Kumar to Dr.
Rawal.
Rawal. And he has taken undertaking before the court through counsel that within 48 hours he will submit the iPhone and laptop. He has not cooperated.
Main accused.
Main accused. Yes.
Main accused. And that electronic equipment is provided by Pavan Kumar. They are not cooperating. And the court order is there. He is supposed to appear before I am coming, your lordship.
Lordship will kindly say at this stage whether my custodial interrogation with her. Because I have cooperated.
It is-
Because they
it
have
is
not
a
getting the articles, that does not mean I am not cooperating.
No, how he is not cooperating, that you explain.
And because they have not got the laptop and the mobile. That is the allegation, that I have given laptop, mobile to the prime
And
accused.
now,
That is what
It
they are
is
asserting
in
now.
possession of the prime accused. In whose possession laptop?
That they have not found out. And
it is.
so far my
because-
instruction is concerned, the prime accused is giving his mobile and the laptop.
To whom?
Whether that mobile laptop
CD
is
is
this.
there, your lordship. CD is there.
No. You answer my query that after getting interim bail, the petitioner has appeared before you. And you have recorded his statement. Now you are alleging that he is not cooperating. My query is in what manner he is not cooperating?
Yes.
Why?
Suit, and there is a date given by 1/7/2025 by learned court below. And he has given letter to IO that at page number 45.
No, that is not my query. He was granted interim bail on 16/7. After that, after getting interim bail, is there any accusation that he is not cooperating? If after that he has not cooperated, then we may consider vacating.
They're concealing the fact.
Their main contention is that they
They're
are
concealing
finding
the
the
fact
laptop and the
because-
mobile.
Because in the laptop and mobile, there is a certain incriminating documents are there. So those are not yet handed over. The number which is reflecting in the invoice of this mobile and iPhone, it is in their possession.
And they have even searched my office and my house.
IU is asking repeatedly, but he is not cooperating because now he is under bail. When they will get an protection, it is very difficult to get the investigation. And moreover, in the new PC Act, even the bribe giver is also come under the ambit of the PC Act.
No,
After
those questions we are not going.
That is during trial.
This is the order which they are not cooperating, consequent upon which we have filed a cancellation of bail. This is the order. This is the order of Ravindra Kumar Rawal.
Oh, here we are concerned only with the petitioner Pavan Kumar Bora. Whether he is cooperating or not. Co-accused is not cooperating. How he is not cooperating?
And some medical
Is it-
document.
we have
He has given medical document. It is there. In page number,
No, I am not getting you. When IO says he is not cooperating,
what
he has to explain in this, he is not appearing before me, or he is remaining silent. He is not.
statement is well.
that he is not pulling well. His letter is there. Letter is there in page number
That means his
45.
cooperating is giving reply.
Investigation in the CBI case number, the instant case so and so. It revealed during the investigation, this is given by the IO to the Pavan Kumar. It reveals during the investigation that an iPhone model number so and so, bearing number so and a silver color M2 MacBook Apple laptop bearing number so and so were purchased by Assam Chemical and Instrument Corporation on 25/2024 from one digital Thana Road near Gini and Johnny Gorali Jorhat.
Yes, thereafter.
That is prior to my getting bail, Lordship. That is on 5/7. Lordship, kindly see that.
Thereafter, he has given a letter to the IO. With due respect, I am to submit that your good.
What is the date of the letter?
Letter is 8/7/25. That is prior to getting the bail.
When is the notice?
It's on 5/7.
Okay, thereafter.
Reply is on 8/7.
Reply. 7. Even he has not appeared before the magistrate to say so that he doesn't want to give his confessional statement, because this is the order of the magistrate, page number 43
That is
of
the
our
main
reply.
thing.
Of our reply. This is the order we have annexed. And he has been given a reflection time also. So if he doesn't like to appear before the magistrate, he is supposed to give
No.
excuses
That-
before the magistrate.
I am
instead of
not,
IO.
I am not getting you. He was
Produced before a
produced
magistrate.
before the magistrate for recording his confessional statement. He was given reflection time. Thereafter, he denied that.
Denied.
He's not denying, he's
Whether
not
that
coming,
amounts
he's
to
appearing.
non-cooperation.
No, he will be produced before the court. Reflection time where he was given.
During the reflection time, he shouldn't, he is not supposed to come in the contact of the IO.
Where he was kept during reflection time. Okay, thereafter.
Specifically written here that he will not be in touch with the IO. Otherwise, it is some sort of influence upon the accused.
Whether that will amount to non-cooperation. That's
So
because I'm
when
not
the-
giving my confession statement.
So when the date is fixed on 1/7/25, he is supposed to appear there, even if he doesn't like to record his statement.
Where is that order?
Page number 43, Annexure B. In our reply. When Mintu Das is produced before me, he has given his 164.
That is his employer, the present petitioner's employer.
Excuse.
What happened on 1/7?
1/7 he has informed that he would not appear.
So he has informed us, IO.
Definitely I will inform her, not
He's
the
supposed to arrive by the order of the court.
And
Because
now
this
also if your
order is of
lordship-
court order.
Now also.
No, but these things happen before grant of
Before granting
interim bail.
Prior, not subsequent.
Before grant of interim bail by this court.
And day after this notice, Lordship, day after this notice 5/7 was given to me to produce those articles. Then I gave a reply. And they have even
Because it
seized
is
the
under
bills, they have
process of
annexed the bills also.
investigation. It is
From
it is
my
under
office, they have-
process of investigation. Still we have,
After 16/7, when you appeared,
22.
whether on 22 he appeared. 22nd.
Diary,
22.
diary.
case diary will get that. Case diary.
Heard Mr. D. Talukdar, learned counsel for the petitioner. Also heard Miss M. Kumari, learned standing counsel CBI. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court on 16/7/2025. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and his statement were also recorded. So
Earlier also his statement was recorded.
he further submits that prior to this also, he had appeared before the investigating officer, and on that occasion also, his statement were recorded. On the other hand, learned standing counsel CBI has opposed the making of an interim bail granted to the petitioner absolute on the ground that the petitioner has not been cooperating in the investigation. He submits that on 5/7/2025, the petitioner was asked by the investigating officer to produce certain items which he did not produce. What happened on 8/7?
8/7, I have given a reply that it is not with me. The
Stop.
mobile and the laptop, it was not with me.
Stop. She also submits that on 27/6/2025, the petitioner was produced by the investigating officer before the Court of Judicial Magistrate First Class Kamrup Metro for recording of his statement under section 183 BNSS. And a reflection time was given to the petitioner with reflection time was given to the petitioner fixing 1/7/2024-25 for recording of his confessional statement. Learned Special Public Prosecutor has submitted that on 1/7/2025, the petitioner did not appear before the Court of Learned Judicial Magistrate as directed by it, and therefore it is apparent that he is not cooperating in the investigation. On the other hand, in response to the submissions made by Learned Standing Counsel CBI, Learned Counsel for the petitioner has submitted that on 8th, in response to the notice received by the petitioner on 5/7/2025, he submitted a representation to the investigating officer on 8/7/2025, stating inter alia therein that he does not have the possession of the articles which were directed to be produced before the investigating officer. He also submits that on 1/7/2025 also he communicated to the investigating officer regarding his inability to appear before the magistrate. Stop. Now, what is your sub?
He was informed over telephone.
He has informed the,
No, no. Why me?
No.
How can I be connected? with
Are
the
you
minister?
not supposed to
oh,
be?
you answer my question.
Minister I have. not.
Now, will you?
Because he is from Johan
He
and
is
the
supposed
minister
to
is of
attend the
Guwahati. If your lordship directs, I'll appear before the minister. That I can do.
court has directed.
Because he is from Johan. In the
Maybe.
petition, 8-7 year lordship will find because of back pain, he could not
But
travel.
he has already
Because
engaged
he
a
has
lawyer
informed.
for this bail application.
That he can do.
Anyone can
That he
file
can
an
do.
application.
That he is not aware because.
I have considered the submissions made by learned counsel for both sides. It appears that the accusation made by learned standing counsel CBI regarding non-cooperation by the petitioner relates to dates prior to grant of interim bail to the petitioner by this court. It appears that petitioner was granted interim bail by this court on 16/7/2025, and after the said date, he appeared before the investigating officer on 22nd July 2025. There is no allegation that after grant of interim bail, he is not cooperating. However, it appears that the Court of Learned Judicial Magistrate, first class, Kamrup, this is Kamrup Metro.
Kamrup, he is from Johan.
Kamrup Metro has fixed the date of recording confessional statement of the petitioner on 1/7/2025, on which he did not appear. Stop. This court hereby makes the interim bail granted to the petitioner on 16/7/2025 absolute with following conditions. You appear before 7 days and go
Before the minister.
magistrate.
Lordship.
The petitioner shall cooperate in the investigation. Stop. Next, the petitioner shall appear before the Court of Learned Judicial Magistrate, first class, Kamrup Metro. You have to appear and who took you to the
IO took me. And in the notice also, they have not stated anything regarding why you are not.
you appear.
That is at page number, your lordship, 40, in his handwriting. Willingness to get a
There
statement.
they have done it.
Willingness to get a statement under section
So
180.
IO took him to the minister. It was.
So, I voluntarily wants to give my statement before the court and I want to disclose all the fact in my knowledge.
That was on 6.
39 is the typed copy, 40 is in his handwriting.
I'll appear then. Because they cannot force me to.
And thereafter this.
Last line case. When will you appear?
Within 7 days, he's from Johan.
How IO will know?
He will appear if I will take him to the magistrate.
Okay.
Otherwise, he alone cannot know. He alone cannot go. Investigation
No,
stage.
because he
I will
has
only
been
have to
given
take.
time for reflection now.
Appear before the appear before the court of learned judicial magistrate, first class Kamrup Metro, in case number RC 2A/2025 GWH within 10 days from the date of this order, and intimate to the said court the reasons for not appearing before the said court on 1/7/2025. And also 1/7/2025. Stop. This anticipatory bail application is accordingly disposed.
So is
Clearly given, in this ensuing period, the investigating agency.
Yes, therefore I am not,
Directly go.
therefore I am directed him to directly
Yes.
go.
Marks.
Item 16.
He has not been received. He's an interim. CD has not been received.
Heard Mr. A.T. Sarkar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who seeks some more time for producing the case diary. The prayer is allowed. Let this case be listed on 29 August. The case diary the interim order shall continue till that day.
Item 17.
About here, 10.21 grams suspected heroin was seized from on Pranjal last night, was present at my house. So my name comes in that.
Is that it?
Anticipatory bail, Lordship. Lordship kindly come to the forwarding of the other co-accused at page 13. Lordship will find the brief of the case. Complainant so-and-so of so-and-so outpost lodged an FIR to the effect that on 17/6/25 at 4 p.m. acting on a source information conducted raid at the house of Rajul Ahmed. This is the present petitioner. So-and-so and found the below noted accused selling illegal drugs. During search, the following items were recovered from his possession. There are 10 plastic vials of so-and-so Lordship containing heroin, approximately 10.21 grams. So-and-so, I will skip all this part, Lordship, which was seized at the PO in presence of independent witnesses. Following all the procedures, so-and-so. During interrogation, it is found that the below noted accused person, namely Pranjal Das, so-and-so, along with the above mentioned accused person running drugs business in the area of Pandi. So Lordship, when they raided the house, the present petitioner escaped from their Lordship. It is from his house that the drugs were found, Lordship. Now he has approached the Lordship with an anticipatory bail. And Lordship, the seizure witness, all of them have stated that it was in his house that the drugs were found. So anticipatory bail.
My lord, it is 10.1 gram.
Whatever.
That is intermediate quantity and it was kept in his pocket. So he had come to visit me. Both of us are Zomato delivery boys. So as that, I know him. So he had come to visit me. Now, what is there in his pocket? I do not. At that time, I was not there in the house. And
Where was that container? What CD reveals from where it was found? From his pocket of the co-accused?
No. From the house, Lordship. This is the seizure list, Lordship. Name and particulars of the person from whom seized. The name of the other co-accused is given, Pranjal Das, because he was present there, Lordship.
that is from Pranjal Das. That is my humble prayer.
Then, Lordship,
From Pranjal Das, it was seized, my lord, who had come to visit in my house.
Lordship, may I
to
read
meet.
one statement of the neighbor, Lordship? So he is the witness, Lordship.
Yes. Yes.
ওচৰতে থকা ৰাজুল আহমেদৰ ঘৰত আজি ইমান তাৰিখে 4টামান বজাত ৰাজুল আহমেদৰ ঘৰত পুলিচে আহে। পুলিচ দেখি ৰাজুল আহমেদ পলাই যায়। ঘৰটো সাৰ্চ কৰোঁতে এজন প্ৰাঞ্জল নামৰ ব্যক্তিয়ে ড্ৰাগছ বিক্ৰী কৰি থকা পাই পুলিচে লোকজনক ধৰে আৰু তেওঁৰ পৰা ছয়ঞ্চ ড্ৰাগছ পায়।
From his possession, my lord. That is my humble submission. He had come to visit me. We both are Zomato delivery boys, my lord.
And there is no such material in the case.
Please tell us.
And estimated quantity, my lord.
Then Lordship will kindly read the statement of the other co-accused, Lordship, what he has stated. মই সৰু সুৰা কাম কৰোঁ, মাজে মাজে মই
Okay.
ৰাজুল আলীৰ লগত ড্ৰাগছ কিনা বেচা কৰোঁ।
Heard Mr. N. Anand, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Rajul Ahmed, who is apprehending his arrest in connection with Jalukbari PS case number 250/2025 under section 21B/29 of the NDPS Act. The gist of accusation in this case is that on (17/6/2025), one Manisha Kumar, SI of police, had lodged an FIR before the officer in charge of Jalukbari police station, inter alia, alleging that on the basis of information through reliable sources, a raid was conducted in the house of the present petitioner, and during raid, apart from some other articles, approximately 10.2 grams of suspected heroin was recovered. At the time of raid, another co-accused, namely Pranjal Das, was also apprehended. However, what happened to Rajul? There is no indication that he fled away. Oh, yes. It is also alleged in the FIR that the present petitioner was able to escape from the place when the search was made. Stop. Learned counsel for the petitioner has submitted that the quantity of contraband recovered in this case is intermediate quantity, and it was not recovered from the possession of the present petitioner. He submits that the contraband seized in this case was recovered from the pockets of the co-accused Pranjal Das, and the petitioner was not aware that the co-accused was carrying suspected contraband. He therefore prays, learned counsel for the petitioner also submits that the petitioner is ready to cooperate in the investigation, and therefore prays for allowing him to go on anticipatory bail. On the other hand, learned additional public prosecutor has opposed the grant of anticipatory bail to the petitioner on the ground that the contraband was recovered from the house of the present petitioner, and the witnesses whose statements have been recorded by the investigating officer have implicated the present petitioner and also stated that the petitioner fled away from the scene when the police reached there for raid stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary produced by the learned additional public prosecutor. On perusal of the case diary, it appears that there are sufficient incriminating materials therein, and therefore this court is of the opinion that this is not a fit case for grant of anticipatory bail to the accused, to the petitioner at this stage. The prayer for anticipatory bail is therefore rejected. Send back the case diary.
Item 19.
Lordship was pleased to call for the case there in the last one. It is on one each.
Yes.
They have filed one objection, my lord. I have gone through the objection, my lord.
What was the accusation?
Against me, nothing, my lord, in objection. Whatever they made the accusation is against the another accused.
No, what is your case?
My case is, my lord, that on the basis of some information, my lord, the CBI has the FIR contents in the FIR, this is, my lord, FP is 13, my lord. That I have indulged in one of the Siktaranjan Dev, he has indulged in some corrupt practice, my lord. And thereby he intentionally caused some losses to the university concerned where he is working. And thereby, my lord, he demanded certain monies from me and other persons for in the name of allotting the works order. And thereby they said that 5 lakhs work order have been given to me and another 23 lakhs for which I have paid 2 lakhs. But at the same time, in page number, my lord, 15, the same FIR, they said that that amount yet to be, my lord, delivered. It has not been given. So on the basis of that, my lord, the search was conducted in the vehicle of the main prime accused, Siktaranjan Dev. And accordingly, my office premises also, my lord, search operation was conducted. My mobile phone was seized, my lord, nothing came from that mobile. And one, my lord, this is.
You are Ravindra Kumar Jain.
No, any, my lord, only basis of some surmise and doubt they have, my lord, filed it.
Yes. Page number 4 of. Yes. No, no. This is against the
Against
mail,
other person, my lord.
Chittaranjan.
And on inquiry, they said it is against the rate in the last occasion. They have admitted that fact, it is given against the rate. You can please, and your trustee, the CD will reflect all the conversation and conflict of Ravindra Kumar then and Dr. Chittaranjan. Is a chatting, your chatting is there, you can,
What it indicates? What it indicates? No, what it indicates? No, you have gone through or not? So whether it indicate that money has been transferred or it still remains in the realm of accusation. So because in the FIR, the accusation has been made that it is suspected that he will be handing over 2 lakhs. Thereafter, no, that therefore, thereafter, during investigation, is there any? No, that he is saying that he has paid for him.
It is, my lord, from February 24 to 31st March 24, my lord.
Then that due to get undue evidence. Chittaranjan is senior professor.
The money was not paid by me, my lord. Money was paid by the, my lord, proprietor of the Jaladhar. And the so far, the, my lord, their indication is that we, my lord, the, and so far the.
Matter is still under investigation. This has been connected on 1/7/2025.
And
Investigation is required. The protection is granted and that even it becomes very difficult for investigation.
Why? What you do in custodial interrogation? What you do? What you do separately from which you cannot do if he is cooperating? No, I just want to understand. What is the distinction? No, you indicate what are the materials at this stage which would. So if he cooperates, if he appears before you, he has not yet appeared. Will it serve the purpose? No, but you are representing the IO. Okay, gay. You flag mark the WhatsApp chats. I'll go through it. Let me go through it. Heard, Mr. Mr. P. Mohanto, learned counsel for the petitioner. Also heard Ms. M. Kumari, learned standing counsel NCB. This application under section 482 of BNSS has been filed by the petitioner Ravindra Kumar Jain, who is apprehending his arrest in connection with ACB Guwahati FM, case number RC 0172025A0007. I'll dictate it in chamber. You take back the case diary after from the court master on Monday. Oh, okay, I'll consider everything.
My lord, one thing, section is 7, my lord, PCI. Section 7 is also not applicable to me because my lord, I am a businessman by profession. And moreover, my lord, is so far their allegation that I am not the proprietor of the Jaladhar. The other proprietor is a Kamal Jain, my lord. I am not the proprietor. And so far, my lord, the money is given there, that is by the proprietor of the Jaladhar against the rent of office and residence who took at my lord Agartala.
Okay.
So, my lord, this to be considered.
I'll pass the orders in chamber.
Pass it.
Sir, item 20.
Kindly peruse office note dated 6/8/2020.
Fix it.
25.
Yes. What should we do? We'll await service report. What is your submission?
What?
Miss, what is your name?
FA.
Mr. F.A. Ali, learned counsel for the petitioner. Also Mr. K.K. Parashar, learned additional public prosecutor. On perusal of the office note dated 6/8/2025, it appears that the notices issued to respondent number 2 and 3 by registered post have returned without service with a postal endorsement. Addressee within inverted comma, addressee out of station, comma, RTS within inverted comma, close. Thereafter, fresh notices were issued to the said respondents. However, neither AD card nor unserved notices have been received by the registry till date. So, await further. Registry is directed to place the track consignment report of the notices sent through registered post with AD to petition to respondent number 2 and 3 before this court on the next date fixed. Let this case be listed on 28th of August.
Item 21 and 22.
Publish.
Your Lordship, my senior will appear in this matter due to some difficulty. He has to leave from court. Another one prayer is there, Your Lordship. Since TCRs were called for and it's tagged along with the division bench. In another, criminal appeal number 434 of 2024. So Your Lordship may kindly, if Your Lordship may kindly give the direction to the registry to call for the TCRs or scan copy of the TCRs along with this matter. Since it comprised from the same judgment. That is already condoned. This is for being
For what purpose these interlocutory applications are?
suspension of the sentence.
Where is the trial court records?
Tagged along with another.
Which case?
434 of 2024, which is pending before the division bench, Your Lordship. From the same judgment, 4 accused appellants are there who has been convicted. two of the appellants were convicted under 302, Your Lordship. So the TCRs were called for and it is tagged along with this.
How it is that some of the accused case is pending before division bench?
Should from the division bench that more than 10 years should be.
These are okay. Mm. Okay. Heard Miss, what is your name? Heard Miss S. Jain, learned counsel for the applicants / appellant in item number 21 and 22. Also heard Mr. K.K. Parashar, learned counsel for the petitioner, has prayed for a short adjournment on the ground of personal difficulty of the conducting senior counsel for the appellant, Mr. B.D. Kaur. Stop. She also submits that in this case, the trial court records would be required. However, same are already called for by a division bench of this court in connection with criminal appeal number 434/2024, which is in which some of the co-accused persons have preferred the appeal. Stop. The registry is directed to get a scanned copy of the trial court records, which is available in the records of criminal appeal number 434/2024, and place the scanned copy along with the records of this case before the next date fixed. When?
20 or 21st.
Let this case be listed on 22nd of 24, 27th, 27 August. Years.
Lordship, not 10 years, Lordship, it's a NDPS case, 6 years, Lordship. Then last day, Lordship, it was said this anticipated, this suspension, Lordship will consider after receiving of the LCR, Lordship. Well, Lordship, on the short submission, Lordship, only.
No, he's praying for adjournment. First, we have to decide his prayer. If his prayer is not allowed, then I will hear you. But if his prayer is considered, under what provision? Conviction?
Conviction, Lordship, 21B. Intermediate quantity, Lordship, 3 months already in jail, Lordship, he is in jail custody from 6/3/2025, Lordship. I can satisfy, Lordship, if Lordship 10 minutes time allowed, Lordship.
But he will oppose.
He's opposed, Lordship, his argument will be hard later, Lordship. My part, I may allow to continue because, Lordship, I'm rely on some judgment, Lordship, for judgment, and moreover, Lordship, it's a case of, Lordship, intermediate quantity, Lordship.
But he is not conceding. He will oppose your, and he's seeking time for preparation.
Record is LCR is there, Lordship.
Mr. B. Chaudhary, learned counsel for the applicant / appellant. Also at Mr. K.K. Parashar, learned additional public prosecutor, who seeks a short adjournment on the ground that he has not gone through the LCR. Who prays for an adjournment on the ground that he needs some time to go through the scanned copy of the trial court, go through the trial court records before he makes his submission. The prayer is allowed. Take 22. List this matter on 22nd of August.
That day, Lordship, they should not take time, Lordship. Otherwise, they will take the same plea, Lordship. They have not gone through the record, Lordship. Because it's always come in the order and it's listed last of the list, Lordship. Is there?
No, let us fix it for hearing.
Lordship,
You
sir,
may-
that suspension was not the lordship, that petition is still pending, lordship. Because 3 months in jail, lordship, 6 year, lordship, the 37.
You
bar
file
will
a
not come, lordship.
application for expeditious hearing. We'll fix the matter for full hearing instead.
And lordship, when lordship,
On it,
2012 case is not till lordship in the list of hearing list, lordship.
Because once you get interim, you forget the main
That-
case.
Sir, I'm ready to have, lordship, I'm ready to there for
On
you, for
18th,
the survey.
on 18th. 22nd.
22nd. May I place lordship some judgment, I bring lordship, may I place that judgment, lordship, it will help the court. lordship.
On that day.
Alright.
Item number.
May I please, lordship, lordship, here is a delay, lordship, while preparing the revision petition, lordship, as per office note, lordship, the notice was not served upon the respondent number 2, lordship.
You have to take steps.
Yes, lordship, the steps may be issued through officer inserts of the concerned PS, lordship,
Okay.
and lordship.
Heard
the-
Mr. S. N. Krishna Tre, learned counsel for the applicants. Also heard Mr. K. K. Parashar, learned additional public prosecutor. The office note dated 6/8/2025 shows that the notice is issued to respondent number 2 has returned with an endorsement insufficient address, RTS. No, you have given insufficient address.
Lordship, insufficient address, lordship, I have given the address as per the FIR and as well as per the lordship criminal appeal, and in the appeal they have appeared. In the same address, lordship. Can be given to them with,
The son of Abdul Khalik. Address is complete address. Even pin code is there. Okay. Let the in view of the aforesaid fact, the petitioner, the applicant is directed to take fresh steps for issuance of notice upon respondent number 2 through the officer in charge of jurisdictional police station. The petitioner shall submit written up notices along with the copies of interlocutory applications and annexures to the registry of this court. Same shall be forwarded to the officer in charge of concerned police station. Stop. The officer in charge of concerned police station is directed to submit a service report after effecting the service of notice on respondent number 2 before the next date fix. Let this case be listed. No, September Adyo. On 3rd of September.
May I pray, lordship, during that time, the petitions may not be taken into custody, lordship, otherwise the revision petition will be in flux of therefore they have to undergo only 1 year in imprisonment, as per the.
This is revision against
Yes, lordship, the.
conviction.
Yes,
No, no. Now you are moving outside. You are on bail.
I was on bail but lordship, because of the delay, lordship, the Lanet Trial Court has already issued warrant for to ask lordship to go undergo the sentence, lordship. This is the difficulty, lordship. They have preferred an appeal and appeal got dismissed against that.
Appeal got dismissed. Okay, then we have to wait till service.
The 1 year imprisonment was.
No, for whatsoever reason.
25. Petition may be taken.
Chamber of Creators. Yes,
My lord, revision petition, my lord, the revision petition notice has not been issued till now. This is against the judgment and order dated 26/3/25, my lord.
now why this I is there?
I have filed for, my lord, bail, suspension of.
Revision petition.
Nadia.
Yes,
But, I found, no, it's long back, it was filed, my lord. No, my lord, the suspension,
you don't have copy of the
my lord, 3 years convicted under section 326 for 3 years, my lord. And now, my lord, the petitioner was directed to appear before the court after 1 month back, and he is pending arrest, my lord. So, my lord, 3 years, my lord, 326, lordship. In this case, my lord, the evidences of the PW, PW1, PW2, my lord, and PW.
you preferred an appeal.
Appeal, my lord.
Appeal was dismissed.
Appeal, this is, my lord, 5% were convicted, my lord. Convicted by the trial court, my lord. On appeal, my lord, other 4 were acquitted, my lord. Now, accusation against the petitioner is that he along with others, my lord. The one part of the statement was believed, on another part was disbelieved. I can show your lordship from the evidences of PW1, PW2, PW3, which clearly shows that there is no eyewitness of the alleged incident.
Okay. Heard Mr. T. Laskar. Sorry, J. Laskar, learned counsel for the petitioner. Learned counsel for the applicant. Also heard Mr. K. K. Parashar, learned. Under what provision you have filed this?
The lordship, as far as the revision is concerned, my lord, there is no separate provision.
There is no provision. Then you find out the provision,
No, my
then
lord,
we,
380 is there for, my lord, for appeal, my.
and revision,
Revision, my lord, in the section itself, my lord, provides in the event that the court admits, my lord, court can grant this, my lord.
which provision?
My lord, earlier it was, my lord, 397/401. Lordship,
Now,
now lordship, it is 442/438.
which are you, which one you are relying?
My lord,
Why have you not mentioned the provision in your interlocutory
now,
application?
389, my lord, earlier CRPC, my lord, it is for pending appeal, my.
No, why have you not mentioned the provision under which the,
No, my lord, in 442, my lord.
you come prepared?
No, my lord, it's here. My lord, calling for records, my lord, calling for records. When calling for such records directs the execution of any sentence or orders is suspended, and if the accused is in the confinement that leaves on bail or on his
Which is
own-
the provision?
My lord, 438, my. Calling for records to exercise powers of revision, my.
this application, this interlocutory application has been filed by the petitioner, by the applicant, praying for suspension of sentence and allowing the petitioner to go on bail during the pendency of the connected criminal revision petition number 159/2025 filed by the petitioner. Stop. In the connected criminal petition, criminal revision petition, the petitioner has impugned the petitioner, namely Abdul Hasim Laskar alias Kutir Ali Laskar, has impugned the judgment dated 26/3/2025, passed in Criminal Appeal number 14/2022 by the Court of Learned Additional Sessions Judge Kachar Silchar, whereby, stop, by the said judgment, the appeal was allowed and partly modified. By the said judgment, the judgment, Katidyoke appeal was allowed. By the said judgment, the judgment dated 16/3/2022, passed by the learned Judicial Magistrate First Class Kachar in GR case number 2496/2002-12 was partly modified. Which court sentenced you,
My lord,
convicted you
convicted initially by a judicial magistrate first class now
for 3 years,
for 3 years.
and appellate court
So upheld 3 years. Only
upheld that?
3 years. Under section 326.
Learned counsel for the petitioner has submitted that the trial court, that is the Judicial Court of Learned Judicial Magistrate First Class Kachar Silchar, had convicted the appellant, had convicted the present petitioner under section 326 of the Indian Penal Code and has sentenced him to undergo imprisonment for 3 years with a fine of 10,000, and in default of payment of fine to undergo. What was the default stipulation?
Told my lord, trial court judgment.
You have mentioned nothing in your
My lord, default clause, my lord, 10,000. 10,000. Convicted under.
I am deferring this matter.
So it's all lost. I'm explaining, sorry, my lord.
You have come unprepared before the
Page 49. I'm sorry, my lord. Page 49, convicted under section 326, read with section 149 IPC, simple imprisonment for 3 years with fine of rupees 10,000.
And what is the default stipulation?
For each default, RI for 6 months, my.
And in default thereof, to pay, to undergo further imprisonment for 6 months. Learned counsel for the petitioner has submitted that as petitioner has challenged his order of conviction in the connected, has challenged the order of conviction and sentence imposed on him in the connected criminal revision petition number 159/2025, and as the sentence imposed on him is for a short term of 3 years during the pendency of the connected criminal revision petition, he prays for allowing the sentence to be sentence imposed on him to be suspended. He submits that unless same is done, the criminal revision petition filed by him would become infructuous. On the other hand, Mr. Parashar, anything? 3 years. I have also heard learned additional public prosecutor who submits that considering the short period of sentence imposed on the petitioner, the connected revision petition should be expeditiously heard. Stop. I have considered the submissions made by learned counsel for both sides. Since the sentence imposed on the petitioner by the impugned judgments is for a short period of 3 years. Hence, considering the facts and circumstances of this case, the sentence imposed on him by the impugned judgments, impugned judgment dated 16/3/2022, passed by learned judicial magistrate first class Pachar Silchar in GR case number 2496/2012, which has been upheld by the impugned judgment dated 26/3/2025, passed in criminal appeal number 14/2022 by learned additional session judge Kachar Silchar, is hereby suspended during the pendency of the connected criminal revision petition 159/2025. The petitioner shall be allowed to go on bail during the pendency of the connected criminal revision petition of rupees 30,000 with one surety of like amount, subject to the satisfaction of the trial court, that is the court of learned judicial magistrate first class Kachar Silchar in GR case number 2496/2012. This interlocutory application is accordingly disposed of. In criminal revision petition, notice has not been issued.
Yeah.
Heard Mr. J. Laskar, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. The trial court, scanned copy of the trial court records have been received. Therefore, this case is ready for hearing. Let this case be listed for hearing after 6 weeks. Okay. Cut it up, let this. It appears that no notice was issued to respondent number 2. Where is your notice was not issued in I also.
My lord, considering that only 3 years, my lord, and in the meantime, he will take into custody. Now, my lord, to court, my lord, on that day, my lord, it was listed for the court, my lord, and court.
Manmohan Kato. In I.
Now, my lord, with all respect, lordship. Lordship, in this case, my lord, if the case is not suspended, my lord, the petitioner will be taken into custody, my lord.
No, last what likho. instead of bail, interim bail, let notice be issued to respondent number 2. List this matter after 4 weeks. And in this criminal petition also, it appears from record that scanned copy of the trial court records have been received. However, notice to respondent number 2 has not yet been issued. Hence, issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Same steps are same. It will be in the IA also. IA is not disposed of. You are granted interim bail in the IA.
Briefly apply.
Item 26.
May I bring the lordship? Lordship, on last 2 occasions, lordship granted them adjournment, lordship. So today I'm seeking bail on 2 grounds, lordship. First is that lordship non-compliance of 47, lordship, and the second one is lordship. That,
It is a
and that
appeal.
no,
or
lordship, it's a bail application, lordship. Bail application, lordship. I'm seeking
bail
on
application.
2
Why
grounds.
it has come up in orders column?
Lordship, actually, I filed that final complaint on last occasion, lordship, because in the original bail application, lordship, the final complaint was not there, lordship. It was half for the convenience of the honorable court and for us also. That is why I have filed this IA to bring on records, lordship, as
Bring on record what?
lordship, that final complaint.
You
It's
could have filed an
already
additional affidavit instead of filing it. What relief you are seeking in IA?
through IA, lordship, I have brought the final complaint for the convenience of the honorable court to see the whole.
No, what is your prayer in the IA?
Lordship, to allow the lordship to include this as additional document with the record, lordship.
We'll allow it.
Lordship, mainly seeking bail, lordship.
No, but today it is fixed in the orders column and you have filed an IA. We are allowing the IA and list the bail application on some other day.
Actually, lordship, what happened last occasion, lordship, lordship asked me to show the 47 as well as that I was making submission on the point, lordship, that seized contraband does not fall under the definition of the lordship section 2. So, lordship, that is why I filed this, and it is available, and even it is available in the PCR also, lordship, in the page number 56.
We'll fix a short date. We'll first dispose of this IA. What is your prayer in the IA?
What if this final complaint may be part of the record taken?
For this, you could have filed an additional affidavit instead of filing a separate IA, because no separate relief is sought for.
Otherwise, lordship.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. By filing this interlocutory application, the petitioner seeks to bring on records of bail application number 2058/2022-2025, the final complaint filed by the NCB in NDPS case number 59/2025, along with the annexures. The prayer is allowed. Let the annexures filed along with this interlocutory application be treated as part of records of bail application number 2058/2025. This interlocutory application is accordingly disposed of. Bail application, bail to likhebo same. Heard Mr. A. Rahman, learned counsel for M. Rahman, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for customs, not NCB, customs. Let this case be listed for bail hearing on 22nd. Okay, after 22.
Pending, and they have taken like.
26.
At 10, they have adjourned.
On 26. 26.
May I increase the lordship, my lord? This, my lord, application has been filed by my lord for modification of one, my lord, clause or condition of the bail application, my lord. Petitioner was released on bail on 24/4/2025, my lord. And I have complied all the order passed by this honorable court, my lord. Your lordship kindly come to page 20, directly come to the condition, my lord. Page 20. That condition number 7, my lord. I am not asking, my lord, the petitions of corporate NDPS case, which is pending in the court. The petition appear before the trial guardian when required. The petition shall not directly indirectly make inducement. The petition provide contact details, so and so, shall not leave the jurisdiction.
Okay, 7 appears to be on.
Yes, my lord. Because, my lord, some medical emergency is there, my lord. I can go, my lord, because I can take leave from the, my lord.
Trial is pending.
Trial is pending, my lord.
You are appearing.
I am appearing, my lord. In fact, I also appeared to the NCP with all the documents. Only thing is that, my lord, I am suffering from osteoporosis for long back when I was in the custody. GMC Medical College also stated.
You are
Yes, my-
suffering from
Osteoporosis and BL knee, my lord. Page 35. Arthritis. Osteoporosis of liver. Osteoporosis. And, my lord, advise avoid message prolonged standing.
osteoarthritis.
That's fine. And your
What is BL knee?
Actually, my lord, this osteoporosis is that, my lord, that bone has been broken, my lord.
Osteoarthritis of BL.
Yes, my lord. So that medical treatment, para 6, your lord, kindly come to para 6 of my petition.
Yes, what is that?
Page 8. The applicant back to state that the applicant is suffering from a serious disease, namely osteoporosis BL knee, which made him incapable
Of BL knee.
Yes. To one.
Perhaps it is of left knee.
Yes, ma'am.
You have objection. Heard Mr. N.N.B. Chaudhary, learned counsel for the petitioner. This application, this interlocutory application has been filed by the petitioner, namely Kamalkant Ray, in connection with bail application number 1080/2025, praying for modification of one of the condition of the bail granted to the petitioner. So, learned counsel for the petitioner has submitted that by the aforesaid, submitted that the petitioner was allowed to go on bail by order dated 24/4/2025, passed in bail application number 1080/2025 by this court with certain conditions. One of the condition number 7 attached to the said order is as follows, within inverted comma. The petitioner shall appear before the officer in charge of NCB crime number 10/2023 once in every fortnight till the pendency of NDPS case number 43/2023. Learned counsel for the petitioner has submitted that the aforesaid condition has become onerous for the petitioner as he is suffering from osteoarthritis of knee, and it has become difficult on his part to report to officer in charge of NCB on once in every fortnight due to medical reasons. Stop. In trial, you are appearing. He submits that. Learned counsel for the petitioner, however, submits that the petitioner is fully cooperating in trial and is regularly appearing before the trial court and also abiding by all other conditions imposed by the said bail order. Learned counsel for NCB, Ms. M. Deka, has submitted that considering the fact that the petitioner is cooperating in trial and has shown medical reasons for modification of the said bail condition, she does not have any objection to the same. So, considering the submissions of learned counsel for both sides, this court is also of the considered that condition number 7 attached to the bail order dated 24/4/2025 passed in bail application number 1080/2025 has become onerous for the petitioner, and therefore same shall be treated as removed from the condition imposed by the aforesaid bail order. This interlocutory application is accordingly disposed of.
35. My lord, he was granted bail, my lord, in Umrangchu case case number 2 of 25, my lord, with condition to appear before the IO and that within 15 days. On 11/4, accordingly he appeared on 24.
Yes.
But the IO
In the interlocutory application change করে কিন্তু মন দেখাম মনে ফেলাই dictation, no, this not this one, আগর case dictation দিব লাগে item number 25. Yes.
My lord, the pursuant to that order, my lord, I went to the Umrangchu PS on 24/4. But till then the case, they have said this transfer to CBI, but maybe, my lord, I'm being illiterate. I understood it CBI, but it was CI deep. So, my lord, CI deep. I understood it being illiterate. I understood it CBI. The person came to me, told me CBI. Accordingly, I filed an IA, my lord, before your lordship, and it came up for hearing on 19/7, my lord. It was I was confused with the CBI or CID. Then learned friend, my lord, said that it is CID. Then your lordship was pleased to call for the case diary, my lord. And in the meantime, also, my lord, I have filed an affidavit, my lord, coming to know about the CID case, my lord. On my advice, my lord, the petitioner went to the IO of the CID case, my lord, and appeared on my lord 24/7. 28/7 and 37, my lord. I have filed an affidavit, my lord. In paragraph 6, I have mentioned it. So, my lord, I have complied with even earlier also I tried to comply with, my lord, and now also even though your lordship is not.
So why this I has been filed?
Well,
could not appear before the IO as per the order, my lord, because
Later on you appeared.
like now I appear before the IO, I have got the IO, now I have got the address, my lord. So I appeared before, my lord,
This AB was disposed of.
yes.
Okay.
Two sectors. See, those two sectors in that in his sector. Now he is the sector that he is grant. Numbers are typically manufactured. Some labor start in the quarter.
My lord, I am basically a shopkeeper in the Teen Alley market, my lord, Teen market, my lord, and I have submitted documents connected to my shop, my lord, grocery shop, my lord. I have annexed, sorry, I have submitted before the IO also.
No. What relief you are seeking in this IA?
My lord, my lord, now I have already, my lord, complied. If required, I will further, my lord, cooperate with
If there was to appear before the
IO.
so I think it's what-
You have already appeared.
Yes, ma'am.
So what order we can pass? It has become infructuous.
Yes, my lord. As I have already appeared, my lord, it may be recorded, my lord, paragraph 6 of my affidavit.
Mr. A.R. Talukdar.
AK.
Sorry, A.K. Talukdar, learned counsel for the petitioner, learned counsel for the applicant. This interlocutory application was filed by the petitioner, namely Bahar Uddin, in connection with AB case number 889/2025, whereby he was asked to appear before the investigating officer of Umrangshu Police Station case number 2/2025. Stop. Learned counsel for the petitioner has submitted that when he appeared before Umrangshu PS case number, when he appeared before the investigating officer of
On 24/4. 24/4. Ali. Yes, earlier, this bit is earlier, Umrangshu PS.
Umrangshu PS case number 2/2020.
25. No, that is later on before the CID.
No, his submission. Earlier case was?
Well, Umrangshu PS case number 2/25. And I
two.
appear, I tried to appear.
He was informed by the investigating officer of that case that the said case has been transferred to CBI.
CID will case number kindly say the case.
CID.
NDPS case number. Later on, CID case number perhaps.
That IO has been transferred to the state.
No new case number.
No, not to PS case number is same as that. IO has been transferred to one state. Case remains for one case.
Where it remains, Umrangshu.
So the Umrangshu PS case is transferred to CID PS. But the number is remained the same, no new number is. You are saying so.
IO has been
IO is changed.
IO has been transferred, he transferred to state. But the case remains in Umrangshu, we get the CD, Umrangshu case 25. Commissioner will go.
Where have he appeared now? In this case. Okay, kill it. He was informed by, not by the investigating officer. He was informed by the officer in charge of Umrangshu Police Station that case has been transferred to CID. Later on, where you appeared?
Let's, IO CID, my lord, present IO.
You appeared before the IO of CID.
CID.
Then it is not.
No new number has been made, my lord, same number is, by the same case number. Open with
No.
CID.
No, we will fix it on Monday. Let the PP go through the CD properly.
My lord, may I make it clear, my lord? Umrangshu PSPN report 2025, my lord. When I went there, they said that it has gone to CBI or CBI misunderstood, the petition misunderstood. Then on the last occasion, when the learned friend said that it has gone to CID, then I went to CID and also the Upen Kolita, he is the IO. So I recorded my statement before him.
At the point of the city was not there only.
Yes, earlier it was only this part of.
Case number, this is in the backside,
My lord, maybe recorded, I appeared before the IO of the Umrangshu case number so and so, Mr. Upen Kolita, DSP CID. It will be
How
clear.
CID comes into picture? CID is, you were informed by the OC that the IO has been transferred to CID. The case remains where it was. And the direction was to appear before the IO of that case, not before the Upen Kalita.
Well, he is the IO of the case now, man.
The second page, Kalita, DPSP, I of the case, here is mentioned like this.
That the investigating officer has been transferred to CID. And therefore, there was some delay in appearing before the investigating officer as directed by this court. Later on, he came to know that the earlier IO, namely Upen Kolita, was transferred as Deputy Superintendent of Police to CID./However, he is still the IO of Umrangshu PS case number 102/2025. Learned counsel for the petitioner has submitted that accordingly he appeared before the investigating officer on
24/7, 28/7 and 37. Recorded statement.
on 3 occasions. That is 24/7,
28/7 and
28/7 and 37. Stop. Learned additional public prosecutor, on the other hand, has produced the case diary of Umrangshu PS case number 2/2025 and has submitted that the petitioner has appeared before the investigating officer of the Umrangshu PS case number 2/2025 on 28/7/2025.
And recorded statement, no?
And his statement under section 180 BNSS has been recorded by the investigating officer. As the petitioner has appeared before the investigating officer, though after the time which was granted to him by the order dated 11/4/2025. However, in the circumstances in which the delay has occurred, same is accepted by this court. And this interlocutory application is hereby disposed of.